Good morning, sir. Can you see and hear me?
Yes, I can, thank you.
Thank you. We'll be hearing from Mr. Flemington this morning.
Yes.
Repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Thank you.
Please could you state your full name?
Hugh Flemington.
Thank you for providing evidence to the inquiry today and also for providing a detailed written statement. I want to turn to that statement that should be in a bundle of documents in front of you. Do you have that dated the 19th of March 2024?
Yes, I do.
And it runs to 195 paragraphs.
Yes.
Could I ask you please to turn to page 47 of the statement?
Yes.
Do you see your signature?
Yes, I do.
And can I ask you to confirm whether the contents of that statement are true to the best of your knowledge and belief?
Yes, it is.
For the transcript, that is document reference number WITN 086200100. That now stands as your evidence in the inquiry. It will be published on the website, the inquiry's website soon. I'm going to ask you some questions about it now. Just start with your background. It's right that you qualified as a solicitor in 1996.
Yes.
And in terms of what's relevant to this inquiry, you were employed by Royal Mail Group as a lawyer in the Group Tech and IP team in June 2009.
Yes.
And before then, you practiced as a solicitor, both in firms and in-house, in the areas of mergers and acquisitions and other commercial matters.
Yeah.
So, as I say, you started in Royal Mail Group in 2009. You became head of legal for Post Office Post Office team in Royal Mail Group in August 2011.
Yes.
So it's still within the Royal Mail Group, but on the Post Office legal team. Your evidence is at that point the Post Office legal team was only dealing with non-contentious matters. Is that correct?
Yes.
So the conduct of civil and criminal litigation fell to a different team within the Royal Mail Group.
Yes.
When Post Office Limited separated, so at 1st of April 2012, you transferred to Post Office Limited as an employee.
Yes.
And at that point, the Post Office Limited legal team became responsible for civil and criminal litigation.
Yes.
And at that point, you reported to Susan Crichton.
Yes.
Your responsibilities as head of legal, were they ever written down in a single document?
I believe I would have had a contract of employment, obviously, and the head of legal role would have been defined somewhere.
So defined somewhere, but can you recall roughly what those responsibilities were?
It would be in relation to managing the team of lawyers, managing the budgeting, managing them from a personnel point of view.
And would that have included managing lawyers responsible for criminal and civil litigation?
So there's an important distinction to make here, which is that it would be managing them from a personnel point of view, but in terms of supervising the litigation, that was to be done by Susan Crichton.
We'll come back to that in due course. The reporting lines, were you the only head of legal at this point, or were there other?
Yes, I was the only head of legal from when I was appointed in 2011.
In due course, were there additional heads of legal appointed when you were there?
Not when I was there.
Right, I want to come to the first topic, which is a few matters in 2010 concerning audit data. And the first point is track 2 data.
Mm-hmm.
Can I start, please, with poll 2016959? This is a letter addressed to you, dated 12th of February 2010, from Stephen Dilly at Bond Pierce, who became Bond Dickinson, then Womble Bond Dickinson. If we could just go down slightly. It talks about potential deletion of track 2 data. And we see in the first paragraph under background, it states that track 2 data contains the 15 to 19 character primary account numbers relating to customer transactions, expiry date of the card, information about what the card can be used for and how it should be handled at the point of payment, and other discretionary data. So this is all personal data relating to customers' debit and credit card transactions. Is that right?
I believe so.
It goes on to say that you believe that track 2 data has to be destroyed to comply with PCI-DSS. Now, just pausing there, does that stand for Payment Card Industry Data Security Standard?
I can't recall.
Do you recall what it was in lay terms?
In lay terms, it would be the rules that the PCI operated that you had to abide by if you took card payments in your business.
So the PCI being the payment card industry?
Yes.
Yeah. So there was presumably at the time, or at least Post Office believed, there was a need to comply with PCI standards to delete this track 2 data.
Yes.
If we go down to Fujitsu advice, it says Fujitsu's corporate legal counsel, Jean-Philippe Prenevost, has stated in his email of 12th of February 2010 to you that if track 2 data is destroyed, Fujitsu would not be able to testify that historical data is true, accurate, and crucially unchanged. And you asked some matters to clarify, such as the reliability. That document can come down for the time being, it's just for background. So setting the scene with track data, effectively Post Office wanted to delete data that wasn't essential for branches' transactions or the branch accounts.
So there was a PCI compliance audit done, I believe.
Yeah.
And as part of that, it was found that the system held track 2 data, as I recall.
Mm-hmm. And
the PCI expert said that that was counter to the PCI rules.
Yes, and so going to my question, which was deleting this data, it wasn't data on which the branches relied to generate their branch accounts.
I wouldn't have known, and I can't recall what kind of data it would have been.
Well, if you're asking to delete data that was relevant to the generation of branch accounts, that would seem quite surprising, wouldn't it?
At the time, I would have just known that there was this data that we held, and the question in front of me was, can we delete it or not? And I was told that there was a risk of deleting it in relation to the Horizon cases.
Let's go to the next document. It's FUJ 202300908. And if we could go to the bottom of page 1, please. We see there's an email there from Gareth Jenkins on the 17th of February 2010. Carry on down to the bottom, please. Sorry, that's fine, thank you. So Jeff, Susie, my suggested answers to most of the questions below, prefixed GIJ in bold italics, lower down in the email train. So if you can go down to that, it's page 4, please. And yes, that's great, thank you. You see your email of the 15th of February to Jean-Philippe Prenevost. And you describe below is a magic list of questions. I think should be compiled from a few people today since our call this morning. Would Fujitsu be able to get us responses by close of play on Friday, please? And if we could go down a bit further, please. And we see at 1, GIJ. Sorry, the question is, before Track 2 data is deleted, would Fujitsu be able to say precisely what impact the deletion would have, e.g., what additional data would also be deleted or amended, and if so, how it would be amended? And there's a lengthy explanation there from Gareth Jenkins towards the end saying, the result of this is that the audit of the original message would be changed and it would no longer be possible to assert it has not been changed since originally recorded. Also, the revised audit file would need to be resealed again, indicating that it has not been tampered with since the time of the official change. So, at this time, do you recall if this message was passed on to you?
I don't recall. I remember that the sort of list of questions would have come from the PCI consultant.
Right.
So I didn't have a technical knowledge of what was being asked or what the discussions were around the data.
Were you broadly aware that, well, let's say, firstly, you're trying to delete this Track 2 data. You're aware of that?
So there was a proposal of, could we delete the Track 2 data? And it was trying to find out, is there an issue with deleting that Track 2 data?
Could it affect other data?
Yeah.
Which we'll come to in a second, what that other data was. You were presumably aware that the concern was that if other data in the audit files was disturbed, it could affect Post Office Limited's ability to bring or defend claims concerning sub-postmasters.
So at the highest level, it was explained to me that if you did something with this data, there might be a risk that it would prejudice the ability to bring those cases. But I didn't understand the detail of that.
If we can turn the page, please, to page 6. And if we could go to the bottom, please. We see paragraph 5. What is the probability that the deletion would affect the data contained in the following? And it includes data relating to cash receipts from branch, data relating to transactions. And in particular, data relating to transactions says these may be affected if they are card related. And I think you said you can't remember in detail if you received these answers to the questions. Given these were important questions, would you have followed up on this and got answers to them? Do you think that's likely?
It's possible, yes.
Do you think it's likely?
I don't know, because I can't say for certain whether what then happened would have been a call between the PCI consultant and Fujitsu. This was all very technical, and I wouldn't have understood what they were talking about necessarily in terms of all the different types of data or the implications. So I would have spoken to the PCI consultant about it.
Did you understand, let's go back, understand this much. Firstly, that it was possible for Fujitsu to delete data that was in the audit file?
I'm not sure I would have understood that point, no.
Well, you were here talking about what the effect of deleting Track 2 data would be. If Fujitsu couldn't delete the data, do you think the simple answer would be, we don't need to answer all these questions, we can't delete the Track 2 data?
Yes, I wouldn't necessarily have thought about that, but yes. So
if you turn your mind to it at least, you accept that you must have been aware that Fujitsu could delete files within the audit record.
Or that it might be possible. I don't.
Might be possible. And in this case, what was being suggested is a, let's call it a legitimate deletion. Post Office is considering a proposal to delete data from the audit files for data protection purposes and to comply with this PCI guidance.
Yes, it was driven by complying with the PCI rules.
But the Post Office was aware that in doing that, there was a risk to the integrity of the remainder of the data in the audit file.
So, as I understood it, from my non-technical understanding, it was expressed that there was a possibility it would be harder to bring cases on the Horizon issue if this data was touched at all.
That understanding you have, did you share that with others on, say, EXCO, the Executive Committee?
The PCI matter, I was reporting to Susan Crichton on it as my line manager, and it's likely that the consultant was working as part of the CIO's team.
Do you personally know if this was brought up at board level?
Can't recall.
Do I take it from that you didn't discuss with anyone on the board about this PCI issue?
I can't recall that or any paper on it.
I want to go to the second topic on audit data concerning duplicate transactions. Please could we bring up FUJ 20121097. Could we turn to page 2, please? And the email towards the bottom. Yes, that's it. Thank you. So this is an email from Penny Thomas, dated the 13th of June 2010, and one which has been seen by the inquiry before. It's sent to Sue Lowther, Mark Dinsdale, and Jane Owen. Do those names ring a bell to you?
Mark Dinsdale, because he comes up in one of the other documents in the bundle, but not the others.
Were any of, well, I won't ask the others you don't remember, but Mark Dinsdale, was he in your line management chain at all?
He wasn't anything to do with legal, I remember that.
And it says, we've identified that a number of recent ARQ returns contain duplicate transaction records. And it goes on to explain how that's happened, that the HNGX retrieval mechanism does not remove duplicates. Now, you're aware, well, let's rephrase that, sorry. Were you aware at the time about ARQ and audit data being used for civil prosecution, civil proceedings and prosecutions?
No, my technical knowledge wouldn't have known anything about that kind of thing.
Well, this is June 2010, and we saw earlier, when relating to the PCI matter, you were raising questions about audit data and Post Office ability to rely on it in criminal and civil proceedings. Was it not? Are you saying you weren't aware of audit?
So the questions I was raising in PCI would have been provided by the PCI consultant. I wouldn't have understood all the technical things that they were talking about.
Would you say that's particularly technical, the fact that Post Office were relying on audit data for civil and criminal proceedings?
So I wouldn't know what data they were relying on, just that there was some data that was important to the criminal cases.
Let's move on. If we turn to page 1, please, of this. Down, yes, thank you. Penny Thomas's email of the 2nd of July. says, I've just completed a conference call with Mark Dinsdale, Alan Simpson and Jane Owen. I said 5 bullet points down. It says, I talked them through the ARQ's affected list and asked that they confirm whether West Byfleet and Porters Avenue, pausing there, do those West Byfleet and Porters Avenue ring any bells for you?
No.
West Byfleet and the Seaman Misra trial, does that?
So the name Misra rings a bell.
Were the only cases listed that had progressed to court. I asked them to confirm whether transaction records for West Byfleet had actually been presented at court or whether records had only been passed to the defence expert. So there appears to be a discussion here on how these duplicate, the effect of these duplicate records in the audit data had affected any court proceedings. Were you made aware of this at the time?
I can't recall that. I wasn't involved in any of the criminal litigation, so it's unlikely that I'd have been given any information about the cases.
We'll come to that shortly. Let's put ourselves in the legal team. On the one hand, earlier in the year, you were dealing with an issue relating to audit data for the PCI.
Yes.
Later in the year, there's an issue about audit data for these duplicate transactions. And your evidence is you weren't aware, or you weren't aware of this later duplicate.
No, I can't recall that at all.
Supposing there, within the legal team, what level of discussion was there about matters between, say, the civil litigation team and your team, which was related, was it IP and IT?
So, if you're talking about 2010,
Yes.
I am in the post office legal team at that point, and there's about 4 lawyers and Susan Crichton.
Yes.
The IPIT team at Royal Mail is separate. The criminal team is separate, and they're based at 2 other different offices.
So there is an entirely separate office from
Yes.
the criminal team. Is a physically separate office from where
So
you
the
were?
criminal team sat in a physically separate office on its own. The Royal Mail IPIT team and the Royal Mail civil litigation team sat in a Royal Mail office, and then Post Office Legal was in a 3rd office at the Post Office headquarters.
So is it fair to say that in terms of day-to-day discussions, the Post Office legal team, your evidence is, didn't really have much communication with the civil litigation or criminal litigation team?
No.
Well, let's move to some of the, to look at that and some of the response to problems raised regarding Horizon. We don't need to turn this up, but in page 12, paragraph 52 of your witness statement, I think your evidence is you don't recall specifically reading the May 2009 Computer Weekly article. Is that right?
That's right.
But you can remember hearing reference to it.
Yes, and in the additional bundle of documents that I was given, I believe there's a reference to being told about it in early 2010.
Can you recall what your views were of the allegations raised when you first heard of them?
I think when I first heard of them, it was in the context of PCI Track 2, and the criminal lawyer was explaining to me that criminal cases existed, and there had been some noise in an article in Computer Weekly.
Can I just ask, when you say the criminal lawyer, who was that?
That was, I believe, Juliet McFarlane. It's in the additional bundle of documents. I think around January 2010.
So you say some noise. Was that the words used?
That's my words. It would have been, in her email, she talks about there being criminal cases and that there are some allegations about the Horizon computer system.
Did you take them seriously at that time?
Yes.
When you said some noise, do you think that the use of the phrase some noise indicates that you're taking it seriously or that the complaints have merit?
Sorry, that was just the words I came out with at this point in time.
Do you recall around this time, so 2010, 2011, whether there were any discussions of bugs, errors or defects within the legal team beyond the Computer Weekly article?
So there were the allegations, I think, in terms of the civil cases. I think.
Are you referring to the Shoesmith litigation?
I think there was a Mandy Tolbert email in the additional bundle of the 7th of October.
We'll come to some of those shortly. Yeah.
But I can't recall whether there was earlier mention of the civil cases.
Did Susan Crichton ever discuss bugs, errors and defects with you?
I can't recall, no.
Let's look at some of the emails on these response to Horizon challenges. Can we start, please, with FUJ 20156-122? If we could go to page 7, please. So an email from Mandy Tolbert on the 17th of February 2010 to David X. Smith, head of change and IS at that point. Do you recall what team Mandy Tolbert was in at the time?
So she was in the Royal Mail Civil Litigation team.
So separate building,
Yes.
separate team?
Yes. Yeah.
It says, has Post Office Limited received requests like this? It's referring to the email below. And if so, has it responded to them? Does the business in principle have any objection to meeting with a computer expert and explaining to him how the system works, possibly even showing him the data? If we go to, well, starting with the bottom of page 5, we see David X. Smith's response there, and over the page, it says, as long as the argument is carried out on the level of what could happen, then we will always struggle to win. Our greatest chance of winning the argument case by case is to fix the debate on what actually happened. And it goes on to refer to 2 cases. The first being Cleveley's. It says, in the case referred to as Cleveley's, an independent expert was appointed. Unfortunately, Post Office Limited and Fujitsu did not manage this spectacularly well and probably fielded the wrong people, or at least very insufficiently briefed people. Sorry, or at the very least, insufficiently briefed people. I read the so-called expert's report, and I have to say it was far from the professional effort I would have expected. Now, pausing there, were you aware of the Cleveley's case at the time in 2010? No.
No.
Did you become aware of the Cleveley's case at any point whilst you were at Post Office Limited?
I can't recall, but I don't think so.
If we could carry on to page 2, please. We have an email from Gareth Jenkins on the 25th of February. It says, Susie, Tom, please see email shared below. This is another example of postmasters trying to get away with Horizon has taken my money. Dave Smith seems to have put me forward as the expert to help on this. And then over to page 1, please. The response says, Gareth, I have asked JP to liaise with Hugh Flemington on this. Don't reply at the moment. I'll let you know in due course how we are going to handle this. Do you recall what involvement you had with this matter, namely whether Gareth Jenkins was going to be instructed to give expert evidence?
No, I was surprised when I saw this, and I think that the Fujitsu account manager would have had my name in mind because I'd been asking about track 2. And if I'd have got contacted by JP, I'm sure I would have, once realised it was about a Mandy Tolbert matter, I would have pointed him in the direction of Mandy Tolbert.
At that point, were you aware of do you recall any conversation with either Mandy Tolbert or with Fujitsu, people at Fujitsu, regarding Post Office Limited's request for expert evidence?
No. I wasn't involved in those cases, and there would be no reason for me to be.
So your evidence is it's simply a misdirected email?
Yes.
Nothing further to do with you?
Yes.
Please could we go to POL 20409718? So this is October 2010, 7th of October 2010. We have an email from Mandy Tolbert. It's to Susan Crichton. We know she was sort of sitting at the top of the tree, essentially, for Post Office Limited matters. There's you and Jessica Madron. Do you remember who Jessica Madron was?
She was Post Office legal lawyer that worked on sub-postmaster contracts.
So, in terms, at this point, was she level with you in seniority?
She was, I think, level with me in seniority at this point. She had been there longer, much longer.
She'd been there longer, but in terms of your actual postings, you were level.
I can't recall the precise classifications, I'm afraid.
Says, Dear all, we need as an organisation to determine how best to deal with all the cases where allegations are being made about Horizon and where there is money owed by the former postmasters to the business. Why were you being brought into this email at this stage?
I don't know. I can't recall.
Well, let's pause there. But Mandy Tolbert is in the civil litigation team at Royal Mail.
Yes.
She must have an understanding of where responsibilities lie for issues such as civil litigation within the group.
Yes.
She's emailed a relatively small distribution list of 3 people. Correct?
Correct.
Can you explain why Susan Crichton was included in that list?
I would assume because she's head of the Pole legal operation at that point.
And was it actually the case that you were included because with working on the Post Office legal team, you were being involved in determining the strategy for responding to Horizon challenges?
So I can't recall being involved in that strategy. When I saw this, I thought it was possible that I'd been included because we were starting to plan for separation.
Why would that be a reason
So
for you to be
at
included?
separation, we would have to take civil litigation cases on.
So that's including you not as a in terms of advising on the separation itself, but almost in preparation for your work to come.
Yes, in terms of planning for separation,
Yes. So
but not me taking on civil litigation or being involved with civil litigation.
so is your evidence at this stage that again this was just an email sent to you and you weren't involved in assisting with Post Office Limited strategy on responding to Horizon litigation?
Correct, I can't recall being involved in that.
So you can't recall that, or are you firmly saying you? Well, no. Let me rephrase that. Sorry. Is your evidence you can't recall being involved in the response to Horizon challenges, or your evidence that you're positively saying you weren't involved?
I can't recall, but it would be very unlikely.
If we could just go down, please, to include the paragraph starting number 1. It says, should we wait until the conclusion of the case of Misra, which is currently going through the criminal courts? You said you're now aware of the case of Misra, Seema Misra.
So I was aware of the name because right at the beginning of 210, Fujitsu emails me, probably because I've been dealing with Track 2 issue, and asked me, did I know who was dealing with a case called Misra? So I found out who that lawyer was, and I told the Fujitsu lawyer who'd asked me. So that was my involvement with Misra.
Further on in this paragraph, it says, assuming that the case is concluded within that time period, some of the issues set out below will fall away, but if it is adjourned or we lose it, the following points will become relevant. Misra is the prosecution case involving Izzy Hogg, one of the lawyers used by Postmasters for Justice. If the prosecution is fully successful, it will make the civil claims much easier to deal with. If the prosecution is only partially successful, then it is likely to make the civil claims very difficult to proceed with if we cannot rely on the Horizon data. Can you recall any discussion about whether the Misra case was being used as a test case?
No, I can't.
Could we please look at Pol 30's55590? And if you can go to the bottom, please. This is an email from Mandy Tolbert again on the 21st of October. Your first, it says to Hugh Flemington. It says, I've been made aware of the fact that many of us are on annual leave next week because of half term. In the circumstances, it seems likely that we'll have to reschedule again. Please accept my apologies for this. I'll get my secretary to reschedule. The subject is Horizon. So at this point on the 21st of October 2010, so a few weeks after the email we just went to, Mandy Tolbert appears to be still trying to get you to attend a meeting on Horizon.
And I can't recall any such meeting or going to any such meeting.
But would you accept that you would, again, what appears to be happening is you are being, Mandy Tolbert is trying to bring you into and involve you in discussion on Horizon matters?
Yes, trying to. I can't recall where that went.
Well, if we look up, please, to the John L. Singh email, this is a well-known email to the inquiry. You received this, we can see, on the 21st of October. Do you recall receiving this?
I do, because of the language used and the tone.
And what was it about the language used and the tone that struck you?
Things like the word destroy. I thought that was emotive.
Do you think it was appropriate for a legal professional to use this language?
I thought it was over the top.
This is an email, as you see, it says, Marilyn Benjamin on behalf of John L. Singh. Were you aware of John L. Singh as a lawyer at that point?
No. Other than his name when I provided it to Fujitsu back in 2010.
Did you form a view about John L. Singh at this time?
No, I would have just thought it's an email which uses emotive language. So I'd have been surprised by it, but I wouldn't have formed a view on him.
We see Ms. Talbot was trying to organise some sort of meeting about Horizon. Following this email, in the weeks following, can you recall whether Ms. Talbot tried to rearrange the meeting again, or did that trail run cold?
I can't recall at all. I believe she may have left the business shortly in 2011.
Please, can we bring up Pol 406484? There's a note of conference at Maitland Chambers with Richard Morgan, as a QC as he was. Susan Crichton and you are listed in attendance from Post Office Limited. Do you have any recollection of this conference?
I vaguely recall it, yes.
This was before the announcement of the second site investigation.
Yes, I think so.
Were you aware at that point that there was consideration being given for an independent auditor or expert such as Second Sight to produce a report on the system?
Yes, I think I was.
Who told you about that?
Susan Crichton.
So it's arranged to consider, we see Horizon litigation, and it says the proposal to instruct an independent expert to prepare a report on the Horizon system is the highest risk response to the issue. Now, at this point, there's also civil litigation potentially in the fray from Shoesmiths. Mm-hmm. Can you recall if this paragraph is referring to an independent expert such as Second Sight or the Second Sight exercise, or is this an independent expert to address the specific civil proceedings brought against Post Office Limited?
I couldn't recall.
You say in your statement, we don't need to turn it up on the screen, but it's page 15, paragraph 66, that and this was in September 2011, I should say, the understanding at Royal Mail Group and Post Office at that time was that the system was robust, so it was logical and important that these claims be defended. That's your evidence?
Right.
On what basis did you understand the system to be robust at this stage?
Was that, did you say September 2011?
That was September 2011, yes.
So there had been, I think at that point, possibly the Rod Ismay report on the system.
Pausing there, did you see the Rod Ismay report?
I can't recall seeing that, no.
Well, if you can't recall seeing it, how do you know if that was the basis?
It would have been, I think, talked about.
It was talked about,
yeah,
so...
Yeah. And the message was from, I think, the civil litigation team that the system was robust, from the CIO team that the system was robust.
So your basis for believing the system was robust came from colleagues telling you as such?
Yes. I'm trying to recall if there was any further detail. I think it was a stance at the business that it was robust.
We've seen a couple of occasions here referring to an independent expert, and the documents I took you to before, members of the legal team considering whether independent expert evidence was necessary or desirable, correct?
Do you mean in terms of the conference with counsel in 2012 here?
Well, yes, here, and the documents I took you to earlier, which showed querying whether an expert input was required, the emails from Mandy Tolbert.
Yes.
Why was the legal team considering whether expert evidence was required on a regular basis?
I don't know. I wasn't involved with those civil litigation team or the criminal team, so how they were approaching it was very much down to them.
At this point, when you are involved in the conference,
Yes.
What, if any, internal investigation did the legal team do to understand what documents Post Office Limited held that were relevant to the issue of whether Horizon was robust or not?
I can't recall, but Mr. Singh and Susan Crichton were running the criminal litigation at that time. So I would have expected them to consider that issue.
So that's their issue, you say, not for you. So why were you attending the conference then if it wasn't for you?
I think I've been asked by Susan Crichton to turn up at the conference, possibly because she wanted another view. We only had a Bond Dickinson secondee who was doing civil litigation. Possibly also because it was the holiday season and therefore second sight might be appointed shortly, and she wanted coverage, someone else who knew what the issues were.
And why didn't you, or did you turn your mind to thinking whether you should look for documents held by Post Office that were relevant to the integrity of the Horizon IT system?
I would have assumed that Mr. Singh was dealing with that and doing that very thing.
At that time, were you aware of a problem management team within Post Office Limited?
Sorry, could you repeat the question?
Were you aware of the problem management team within Post Office Limited?
I can't recall that, no.
Did you have any knowledge of something called the KEL database, or the known error log?
No.
Please could we turn to POL 201-07760. If you could go down the page, please. This is an email from Jason G. Collins. Do you remember who that was?
No.
It's 10th of August 2012. It says, after speaking with Andy Garner today, do you remember who Andy Garner was?
No, I remember the name, but not who he was.
I asked him to draw together the email below to enable me to forward to you for site advice. It says, my understanding is that all matters Horizon should pass through you before any agreed actions to support wider activity is made. Were you at this point the point of contact essentially in the legal team for Horizon matters?
Not that I can recall. I was surprised when I saw this email because I cannot remember being bashed as such.
Can you explain why Mr. Collins would have been misunderstood on that issue?
He may have been given a missteer by Mr. Garner. I had worked with Mr. Garner before. I can't remember in what context, but he would know me. So he might have thought that I was the person he knew in the legal team and that Jason should reach out to me.
And was there a single point of contact for Horizon issues at this time within the legal team?
I can't recall, sorry.
Could we look, please, at Poll 00... Oh, sorry, sir.
Yeah, by this time, of course, Mr. Flemington, separation had occurred, had it not?
Yes, that was on the 1st of April.
And so no doubt there were processes being put in place for dealing with these issues within Post Office Limited as opposed to Royal Mail.
Yes, I believe so. Unfortunately, my father passed away unexpectedly on the 1st of April. So the first 3 or 4 weeks I wasn't around in the business.
No, I'm sorry to have heard that, but I wasn't being critical. I was just seeking an explanation for why you may have been included in things, because this was all new in reality, wasn't it?
Well, I was about to say that Susan Crichton and Jarnell Singh would have been sort of working up and setting up the criminal prosecution side of things in those few weeks. I know that there had been some of the MPs reaching out by this time, and that was driving a discussion about would a second side sort of independent review be created. And as I said, I was surprised when I saw myself being badged in this email as all matters Horizon should go through Hugh. It may have been they were aware that I was being involved in the second sight things such as the conference with counsel by Susan Crichton.
Well, it may be no more and no less than, you were the head of legal officially, and Susan Crichton was your boss, and she's copied into it.
Yes, yeah.
All right, fine.
So, rounding off those emails, Mr. Flemington, that you've been taken to, we see in your evidence, actually, it's page 5, paragraph 21, please. Thank you. You say, my involvement with Horizon was initially sporadic and peripheral, and you refer to a specific example there relating to resourcing for John Longman. You say, so sporadic and peripheral until the end of June 2013, when, before going on sabbatical from 12th of July to around 3rd of September, I became involved in the response to the emerging issues regarding Horizon. So having gone through those documents, just to summarise, your evidence is, whilst you may have been copied in on various things or taken to conference, you remained, you weren't involved actually in the strategy of responding to Horizon matters.
It was a very ad hoc engagement.
And secondly, at least following separation at least, your evidence is that responsibility lay with Susan Crichton, within the legal team.
Yes.
With Susan Crichton and John Elsing.
Yes.
That can come down, thank you. I want to look at a different topic now, and it's the issue of how criminal matters were dealt with in the department. You state candidly in your witness statement that you had very little civil litigation experience. And did you have any criminal litigation experience?
No.
Presumably you were aware, well, you say you became aware, sorry, of prosecutions being made by Post Office in 2010 or 2011?
It's 2010, it's mentioned, it's that track 2 PCI.
So it's that point when you're aware, yeah.
Yeah. But literally of their existence, not any detail.
When we get to 2012 and separation, we'll come to the precise scope of it, but you take over line management of John L. Singh.
Yes.
I want to just go over a couple of issues on your knowledge of criminal law. Presumably you were aware of the criminal standard of proof, convincing the jury such that it's sure of guilt.
So, in terms of the criminal side of criminal cases to be taken by Pole Legal, I had already agreed with Susan Crichton that because I had no knowledge of criminal law, I felt unable to supervise John L. Singh on criminal matters.
Yes, I will come to that in a moment, but
yes.
If we can just go through what your knowledge of a few matters of criminal law. Firstly, were you aware that Post Office Limited, if it brought to prosecution, had to convince a jury such that it was sure of guilt?
I was aware that we would have certain duties, but I was totally reliant on Mr. Singh advising correctly on those.
Okay, I'll ask it again. Were you aware of the criminal standard of proof, namely?
I cannot recall being specifically aware of that.
You say you were aware of certain duties. Presumably you would have known that there was a duty of disclosure on Post Office when it prosecuted cases.
I recall a duty of disclosure being talked about by Mr. Singh or mentioned by Mr. Singh in relation to the context of criminal cases.
Did you understand that Post Office was required to disclose documents it possessed or had access to that might reasonably be considered capable of undermining the case for the prosecution or of assisting the case for the accused?
I can't recall what specific knowledge I had on the criminal cases.
Were you aware that Post Office owed a duty of disclosure following conviction?
Again, I can't recall specific awareness.
well, actually, you've said it in evidence, we don't need to turn there, but your evidence on supervision of John L. Singh is that you would effectively deal with normal management issues, as you put
Yes.
it. I take that, you say it's matters like annual leave and salary reviews.
Yes.
But criminal prosecutions, you say those were supervised by Susan Crichton.
Yes.
Were you aware of what experience in criminal law Susan Crichton had?
I wasn't, no.
So at this point, Susan Crichton, was she responsible for the entire legal department?
Yes, she was effectively the de facto GC.
So a much wider remit than you.
Yes.
Miss Crichton's evidence was that she had no criminal law experience. In those circumstances, why would she agree to supervise Mr. Singh's work?
I don't know why she decided to, but she did decide to.
Are you aware of how Miss Crichton supervised Mr. Singh's work?
No.
Was in effect Mr. Singh left to run the prosecutions independently, based on what you're saying, without supervision?
I couldn't comment on that because I don't know what interaction there was between Susan Crichton and Mr. Singh over the criminal prosecutions.
Could we turn, please, to poll 20141-439? And if we could start with page 3, please. Sorry, page 2, my apologies. At the bottom of page 2. So we see this is an email from John Scott to John L. Singh, into which you're copied.
Mm-hmm.
Do you remember who John Scott was?
He was the head of security, I believe.
And did you have, what working relationship did you have with him?
So he would have been, I think at the time, reporting into Susan Crichton as I was.
Sorry, I missed that.
Sorry, I think at the time he was reporting into Susan Crichton alongside myself.
So did you have any working relationship with him?
A little, but not a lot.
Do you remember on what areas you would work with Mr. Scott?
Only on something like this if he would appear and make a comment about someone like Mr. Singh.
We see it's a response. John L. Thanks. Can you send your report? So it's referring to an advice on caution with the whole file, please, as I'd like to see the full officer's report, taped interview notes, etc. Next paragraph says, your report is also very brief, advising a caution, and has not sufficiently outlined the case, supporting evidence, discussion around defence options, and the rationale of why to prosecute or not, or a caution in this particular instance. And we don't need to see the rest of actually, we can go over, please, to the top of page. Yeah, thank you. And we see it says, Cartwright King Solicitors have set a benchmark in terms of reporting and substance of advice and for consistency purposes to ensure decision-making is robust, fair and consistent. This level needs to be maintained. If you can go back to page 2, please. Just slightly down, please. Thank you. We see you remain in copy. John L. Singh comes back with a few comments, and we see John Scott's reply immediately above. It says, when we discussed this yesterday, before I saw the papers, you were critical of CK overplaying their write-up. I acknowledge they are commercial and would wish to increase their opportunity. You were defensive of your position, failed to listen and struggled to take on board learning improvements. I keep with my statement below that CK are the benchmark and you fail to meet it, whether or not this is suitable for caution, prosecution or vice versa, and with Cartwright King. I now have concerns in the overall management of this part of the process. Why did that criticism of Mr. Singh's work come to you?
I can't say why it came to me other than John Scott knew me and knew to speak to me.
But he would know to speak to Susan Crichton, wouldn't he, if it was known that she was supervising Mr. Singh?
I think he may not wanted to have raised this in the first instance with Susan Crichton. I remember I went round and spoke to Susan Crichton about this because I thought it was a criticism that would be levelled at her, not me. And I remember, I think John Scott, it was discussed with John Scott and it was discussed with Mr. Singh in terms of what might have gone wrong, what could be done differently, etc. But this was all with Susan Crichton.
So your evidence is you have a specific recollection of discussing this with Susan Crichton?
Yes.
And to what extent were you involved in providing advice or anything else on the substance of Mr. Singh's work at this point?
This was probably one of the only points when I got drawn into that.
And what did you advise or tell Mr. Singh to do in respect of this?
I can't remember the specifics of where it came out, but I know the matter was thrashed out.
Were you concerned with Mr. Singh's competence at this point?
So at this point, the context for me, I suppose, was that Mr. Singh had been as a criminal lawyer in Royal Mail Group for 17 years. So he was quite a senior practitioner. He'd been recommended by Rob Wilson. I remember early on he'd mentioned after separation that he was organising training for the investigators. And I remember that involved Cartwright King. And I remember Cartwright King after that saying to me he was competent. So there were various pointers which said to me, actually, you know, he knows what he's doing. He's been there a long time. He wouldn't have survived at Royal Mail for 17 years without knowing what he was doing. If I had any concerns like the one raised by John Scott, I would have flagged it to Susan Crichton. But that's the only one I can remember.
Did you have discuss with Susan Crichton whether Mr. Singh was being appropriately supervised?
I can't recall whether that discussion happened.
This is quite a serious criticism from the head of security. Would you accept that?
It is, but I remember at the time feeling that it was slightly personal, that there was some personal animosity between John Scott and John L. Singh.
So that's probably a good time to take the first morning break, if we can come back at 11 o'clock.
Certainly.
Thank you, sir. Good morning, sir. Can you see and hear me again?
I can, thank you.
Thank you. Ms Flemington, I want to ask you a few questions about Post Office Limited's legal approach, the legal team in Post Office Limited's approach to the devolved nations. Was anyone in the Post Office legal team qualified in Scots law?
Not that I recall.
Or the law of Northern Ireland?
Not that I recall.
Was anyone, or at any point when you were at Post Office Limited, did you have a discussion with anyone in the legal team about how Post Office Limited handled prosecutions in Northern Ireland or Scotland?
I can't recall specifically, no. Although at some point it would have been alluded to and talked about in the context of this whole Horizon issue.
In
the context of the whole Horizon issue and dealing with the emerging Horizon issue.
Was that, are you talking after the second site's report when you say that?
Possibly, that's where I'm thinking, yes.
Do you know how the Post Office legal team satisfied itself that it was acting in compliance with the law of Scotland, insofar as it brought prosecutions?
Not per se, no. That would have been something that I would have assumed that Susan Crichton and Mr Singh were dealing with.
And do I take it from that the same applies for Northern Ireland?
Yes.
As well? I'm going to jump forward in the chronology just while we're here. Are you aware of any steps Post Office took to raise issues of Horizon integrity with the Procurator Fiscal?
Not specifically that I can recall, no.
Or the Public Prosecution Service?
No.
You say in your witness statement that you weren't involved in the instruction of Cartwright King, and Cartwright King being a firm, external firm that Post Office Limited relied on for legal advice in relation to criminal matters.
Yes.
Do you know who did instruct Cartwright King?
I had understood it was Mr Singh or Susan Crichton.
Did you take any steps to understand or satisfy yourself as to what Cartwright King's retainer was or its instructions?
I think I would have asked about its retainer on the return to the office after my the burial of my father. It would have been at that point I probably would have looked to see what retainer letter, etc., was in place.
Do you recall what, in broad terms, what they were retained to do?
I can't recall.
Is this another matter that you say would fall to Susan Crichton and John L. Singh?
Yes.
Womblebond Dickinson was another firm instructed by Post Office Limited. And when I say Womblebond Dickinson, I'm including Bond Dickinson and Bond Pierce, etc. Chris Ojard gave evidence that Womblebond Dickinson were at times like an extension of the in-house legal team for Post Office Limited. Would you agree with that?
I could see that he might think that if he's dealing with a particular partner on a regular basis, for example, or a particular fee earner from Womblebond Dickinson on a regular basis, in the context of something like Horizon, purely because there were moments when they probably were providing a lot of support to us.
In terms of Horizon, what was your working relationship with Womblebond Dickinson?
In terms of Horizon issues, I would have dealt with them. I would have dealt with them when they were engaged on Horizon issues, to the extent I was also engaged on that particular Horizon issue. So, for example, in the 2012 QC con, I believe that might have been arranged with their help. And then in the emerging issue the following year in July, they were obviously involved to a degree in that, and so was I. So I would have been involved speaking to them about things then.
Did you think the level of reliance on Bond Dickinson was appropriate or usual for a business such as Post Office Limited?
I didn't at the time think it was unusual or feel it was unusual. We were a growing team. We were originally 4, we'd grown to about 12. We weren't allowed to grow more at that point because there were restrictions on the HR template.
When you say HR template, is that
in terms of head count? Yeah. So you had to still maintain a degree of externalisation to help support on day-to-day matters.
I want to look at some topics now to do with the second site investigation, starting with the effect on prosecutions. Did you receive any instructions about whether or not to continue prosecutions? Sorry, I'll rephrase that. Do you recall receiving any instructions about whether or not Post Office Limited should continue prosecutions of sub-postmasters based on Horizon data once the review by Second Sight had been announced?
I can't recall, no, not specifically.
Susan Crichton gave evidence in her witness statement, which we don't need to turn up, but for the record, it's paragraph 255 of WITN 00220100. Her evidence was, at some point around the time of the separation, I made it clear, including to the security team, that no further prosecutions were to be commenced which were reliant on Horizon evidence. Do you recall that instruction being given?
No, I don't.
Could we look, please, at poll 20180855? So if we could turn to the bottom of page 2, please. We have an email from Rachel Panter right at the bottom about the case of Wiley. It's, as anticipated, please see attached letter from defence solicitors in Wiley asking for our position on the ongoing Horizon investigation. That's relating to Second Sight, isn't it?
Yes. Yeah.
And if we can go up, please, slightly to the email from John L. Singh. Thank you. It says, Hugh, Susan, please see attached Cartwright King's email. I raised this with you briefly. Sorry, I raised this with you and briefly discussed this with Hugh last week with our possible approach. I think you say in your witness statement that you have no recollection of that discussion. Is that correct?
That's correct.
Well, just pausing there. You weren't. This is in your career. You hadn't really dealt with criminal law matters before.
Not at all. No.
So at this point, you're being brought into discussions about Post Office's position on whether to continue prosecutions pending an investigation by Second Sight.
Correct.
And there would be severe ramifications for the business if Second Sight uncovered any systemic problems.
Yes, correct.
It's a high stakes situation.
Yes. Yeah.
Was an unusual moment in your career, would you agree?
It was interesting.
Is it really your evidence that you can't remember the discussion with John L. Singh around this time?
No, because I can't recall, but because I wasn't involved in the prosecutions, my suspicion would be that I would have said this needs to be discussed with Susan.
Well, if we look, you are involved still in this
Yes.
now in the decision making.
Yeah.
Yes. If we go to page 1, please, to the bottom. Sorry, that's fine, thank you. There's some other emails, and John L. Singh comes back on the 10th of July, this time just to you.
Mm-hmm.
Saying, Hugh, what we say to, and then 3 and 4 is, do we agree to defendant's request for stay or adjournment pending completion of the audit report, or let the court decide? What are we going to do with existing pending and future investigations and losses? So effectively, he's asking for guidance on Post Office's position on prosecutions during the second site investigation.
Yeah.
And if we see at the bottom there, he's specifically taken out Susan Crichton out of copy, hasn't he?
Yes.
Well, why would he do that if you weren't supervising on criminal law matters?
So I don't know, because occasionally, sporadically, he would copy me in on criminal law matters. I would remind him that he should be dealing with Susan on them. I took a pragmatic approach, which is if there was anything I could progress to move matters along, then I would. But most of the time when he did this, it would end up being going to get Susan in a discussion with Jarnell over the issue.
If we can go up the chain, please. We see you say, okay, are you able to advise Susan and I, or do you want this to go to counsel? He says, Hugh, if I can have some answers, steer and stance, I can then advise. I think it should be advised Cartwright King and have input from them. And then if we go further up, please, you say, this is now to Susan Crichton, he doesn't seem to be able to do recommendations, does he? Were you having concerns about Mr. Singh's competence at this point?
I think this was about my first dealing with Mr. Singh after separation, after he'd arrived. So this might have been one of my earliest experiences of him. And I'm looking at this chain, I've been drawn into it, I've told him before, actually you're working with Susan Crichton on these matters. I'm trying to make constructive points and move it along. I'm probably getting frustrated at this point. I've got other matters I'm dealing with. So it would be more like frustration over this particular moment than anything larger around Mr. Singh.
So did you remain satisfied that John L. Singh was an appropriate person to be dealing with this issue in criminal prosecutions?
So I would have discussed any concerns I had with Susan Crichton about Mr. Singh. I can't recall on the back of this whether or not I discussed any concerns.
I'm going to go to Harry Bowyer's advice of the 11th of July 2012 now, so just after this email chain. Before I do, I understand it that you accept that you received and read this advice by the 16th of July 2012, is that right?
Yes.
Thank you. Well, we can go straight to the advice then, please. It's Pol 30-26567. So you say it's an advice in the case of Crown and Wiley. And if we can, it sets out the facts of the allegations. We can go down, please, to paragraph 2, thank you. It's referring in paragraph 2, we don't need to read it out, but it's referring to the second site investigation and the ramifications Mr. Bowyer thought that caused. Paragraph 3, please. It says the first consequence is that we have now given ammunition to those attempting to discredit the Horizon system. The argument will be that there is no smoke without fire, and we would not have needed to audit a bomb-proof system. To audit a bomb-proof system. We can expect this to go viral, in that any competent defence solicitor advising in a case such as this will raise the integrity of the Horizon system and put us to proof as to its integrity. As all of our cases depend on the system to compute the alleged losses, this is likely to affect a considerable percentage of our cases. So what were your thoughts when you read that paragraph?
I suppose it's essentially flagging the idea that second site being appointed might end up with a lot of claims against the post office if they find particular issues with Horizon. It's similar to, I think it's mentioned as floodgates in the Morgan conference advice. And I remember thinking at the time that once you had instructed second site to do an independent review, there were two logical outcomes. Either it would find nothing, or it would find something and you would have to deal with the consequences. So for me, that was always a logical possibility.
When you thought about that, did you turn your mind to what should happen in between? So what should happen to criminal cases whilst the investigation was ongoing?
No, because I saw that as for Susan Crichton and Mr. Singh to make a decision on.
We'll come back to that point shortly. If we could go down, please, to paragraph 6, Roman numeral 1. This is the advice Mr. Bowyer gives on what to do on next steps. It says, we should identify the contested cases, civil and criminal, in which the Horizon system has been challenged. We should identify the areas of challenge and how we neutralise them. So advising effectively a looking back exercise of past times when the Horizon IT system had been challenged, correct?
Yes.
When you read this, did you consider whether the Post Office should have reviewed whether there was any material that may assist the defence in those past cases?
I would have expected Mr. Singh and Susan Crichton to already have been looking at that as part of the ongoing prosecution of the cases.
So effectively, you thought it wasn't your responsibility?
No, because I wasn't dealing with those cases and I didn't have supervision or carriage of them.
We could carry on over the page, please. It says, an expert should be identified and instructed to prepare a generic statement which confirms the integrity of the system and why the attacks so far have been unfounded. This expert should be deployed in all cases where the Horizon system is challenged, and he should be prepared to be called to reply to defence experts on a case-by-case basis. Did you agree with that advice?
I wouldn't have had the experience or the expertise to disagree with it.
So you didn't think, for example, that actually it was a Post Office duty to investigate cases on a case-by-case basis to see if there was a problem in the Horizon IT system in that particular case?
So I would have been expecting and relying on Mr. Singh and his expertise and Miss Crichton's supervision of the criminal matters to ensure that all that was done properly.
Well, let's look at some of the emails surrounding this time, please. It's Poll 20144100, please. We can turn to page 2. Thank you, and to the bottom, please. John L. Singh's email of the 16th of July 2012 to Andy Cash, Cartwright King, and you are copied in with Susan Crichton. Mm-hmm. It refers to the defence approach to staying of prosecutions until the review is completed. It says, Post Office view is that such an approach be resisted. Review to be conducted is limited in scope in a few and isolated cases. Goes on to say that there is no legal or forensic grounds to argue defendants will not get a fair trial or abuse of process. There's no reason to justify the case being stayed. And if we can go over the page, please, page 1, down slightly. It's an email from you, 16th of July 2012. John L. Singh, Susan Crichton and Alwyn Lyons in copy. It says one for our 3:30 meeting, I think. Presumably that's referring to the decision on whether to oppose or agree to applications for stays made by defendants.
Yes, this may have been the case that we already had a meeting scheduled on something else. And so I'm saying, okay, this issue has come up. I've tried to distill down on this email what the things are for discussion. And then a discussion can be had on it.
But you're involved in so you're involved in the decision making at this point.
I wouldn't have been involved in the decision making. I would say that I was facilitating the discussion at this point. I've been reached out to by John L. Singh, not of my doing. I'm trying to progress the matter in a sensible way, but I'm making sure that ultimately there's a discussion between John L. Singh and Susan Crichton.
Why did it require you to facilitate a discussion between the General Counsel and someone you say is being supervised by her?
It was a point of frustration from time to time that I would have with Mr. Singh.
What can you expand on that, please?
Because he would email me or include me in an email, and I would say, John L., you're meant to be doing the criminal cases with Susan Crichton, please.
Did you ever approach Susan Crichton and say, please can you exercise more oversight of John L. Singh because he keeps emailing me?
I recall flagging the issue to her and saying I keep getting copied into things.
Do you recall what was discussed at the meeting at 3:30 on the 16th of July 2012?
I can't, no.
Please could we turn to poll 30585155. If we could go to page 2, please. And to the bottom, please. Thank you, that's perfect. So this is an email from you to Susan Crichton on the 24th of July, forwarding an email about a week earlier from John L. Singh. And you say, this is the story text which Jay, presumably John L., put together following our meeting last week. Any comments, please, before we release it? Do you remember the background to this?
I think this was in relation to the appointment of Second Sight and explaining why Post Office had appointed Second Sight. And so I think Mr. Singh will have involved me originally because he will have known that I would have been drawn into the Second Sight issue by Susan Crichton. So, for example, you see me going to that con with counsel. So I'm reached out to, he's obviously needs to put a draft statement together, and this is the progression of that statement.
This is quite a significant time for Post Office Limited's legal team, isn't it?
In the sense of?
In the sense that it's dealing with how to progress prosecutions in the face of the Second Sight investigation.
Yes, although there were lots of important moments along the way.
But is it the case that you were actually being brought into this because it was an important matter for the Post Office legal team to deal with?
I'm not sure that was the case. It might have been more ad hoc than that.
Sorry, can you repeat the last?
It might have been more ad hoc than that, in that I'd been involved by John L. at the start of the email conversation, and it snowballed from there.
If we go to page 2, please, we see there the signature is from Ronan Kelleher, head of PR and media at Post Office Limited. Do you know why a PR person was brought in for this?
No, and I can't recall their name.
The last sentence, actually, no, in fairness to you, I should show you the start of the email, please. Thank you. It says, as this email will most probably find its way into the media, we do need to get the message across from, it should be the start, that we continue to have full confidence in the robustness of the Horizon system and then reinforce it. So I suggest the following tweaking to the proposed wording from Jarnail. And if we go down, please. At the bottom, we see the sentence, when the system has been challenged in criminal courts, it has been successfully defended, which was taken from Mr. Singh's draft of the copy as well. Did you take any steps to satisfy yourself that that was accurate?
I can't recall.
Do you think you should have done?
I would have been relying on Mr. Singh and Miss Crichton to run the prosecutions in the appropriate manner. So if that was required, then I would have expected them to be doing that.
This is slightly different, isn't it, from running the prosecutions? This is a statement on the position in respect of second side, and it's one in which you've become involved. Did you not think it was incumbent on you to check that this was accurate?
So I would have been relying, I suppose, on people who have pulled this together.
Were you aware of the acquittals following trial in criminal proceedings of Maureen McKelvey and Suzanne Palmer at this stage?
No.
Could we please turn to POL 201200723? This is a letter from Cartwright King. We see it's in the case of Post Office Limited and Wiley. If we go down, please, to just under halfway, we see it says the Crown's position on the integrity of the Horizon system is set out in Steve Bradshaw's statement dated 20th November 2012. If we turn to page 5, please. See, that's the statement from Stephen Bradshaw. And it's effectively the statement that was drafted by the PR person we saw. And if we go over the page, again, we see when the system has been challenged in criminal courts, it has been successfully defended. Were you aware of a decision in the Post Office legal team for that copy to be used as witness statements in criminal proceedings?
No, I wasn't.
Do you think that's a failure, that you're sort of involved in an ad hoc basis but not aware of the wider issues and how statements such as that were being used in criminal proceedings?
So I think because I was involved in an ad hoc way, and involved not at my choosing but someone reaching out to me, then it was clearly impossible to control what was happening. I had always understood that those prosecutions were being run appropriately in good faith by Susan Crichton and Mr. Singh.
Did you take any steps to satisfy yourself that that was accurate?
I can't recall.
Can we please turn to POL 201333644? we see this is a witness statement of Gareth Jenkins, dated the 27th of November 2012. If we look over the page, please. Midway down, it says, I've been asked to provide a statement in the case of Kim Wiley. So the Wiley case we've seen appear a few times now. Over at page 3, please. Mr. Jenkins says, I also note a comment made about it being possible to remotely access the system. It is true that such access is possible. However, in an analysis of data audited by the system, it is possible to identify any data that has not been input directly by staff in the branch. Any such change to data is very rare and would be authorised by Post Office Limited. I should ask first, did you see this statement at the time?
Sorry?
Did you see this statement at the time?
No, I wouldn't have seen any witness statements on criminal prosecution cases.
Did anyone in the Post Office legal team make you aware of this aspect of the statement about remote access?
No.
Did anyone at Cartwright King raise this with you?
No.
I want to go to a different matter now, again relating to second sight, and that's about bugs, errors and defects. Can we turn to poll 3060572, please? We turn to page 2, please. So we see your email of the 28th of June. And we can see you referring to various, well, you say it says com statement to include found the 64 and 14 bugs, which we now call the receipts and payments mismatch bug and the suspense account bug. So at this point, I understand you accept you were involved with the response to challenges to Horizon more directly.
Yes, I think this might have been the first day because I'm not in the office. It's a Friday and I wouldn't work on a Friday. But I think Susan Crichton was away on holiday and I think I got reached out to, and probably before this email there would have been a conference call with the people on the email, because this looks like me rushing to get an email out just before people go home for the weekend on Friday because things needed to happen.
We don't need to turn it up on the screen, but at paragraph 115 of your statement, page 27, you refer specifically to this email, and you say that I must have spoken to Jarnail Singh before drafting this email, as I would have been unfamiliar with the criminal case and procedural issues such as adjournments.
Mm-hmm.
First, can you recall what Mr. Singh told you about bugs, errors or defects, if anything?
Sorry, can you repeat?
Did Mr. Singh tell you anything about bugs in the Horizon IT system?
No.
That can come down, thank you. I want to explore your knowledge of bugs. Before June 2013, were you aware of any bugs, errors or defects in the Horizon IT system?
Not that I can recall, no.
Would you accept that in early July 2013, you became aware of something called the Calendar Square bug?
Yes.
And did you know at that point, so by July 2013, when Post Office first had knowledge of the Calendar Square bug?
Is this the Falkirk bug?
The Falkirk, yes, I'm so sorry. Calendar Square Falkirk.
I think in the bundle there is an email, I think, to Susan Crichton and I talking about that bug around that time.
Yes, well, we can turn to that, or at least what I think you're referring to. It's poll 3029628. Just bear with me, sorry, I have to catch up. top we see from Leslie Sewell, and we see your name is at the very far right and left, so it's sent to you. And if we go down, please, to the email from Gareth Jenkins, it's subject Calendar Square. I found some details on the problem. It was first raised in September 2005, and then the fix was applied as part of S90, which was rolled out February-March 2006. Next paragraph down, it says, we reported the problem to Post Office Limited, but I don't know how much of an investigation was carried out into the scope and the number of affected branches. I was not involved in the issue at the time and only really became aware of it as part of the part of the Misra case in 2010. At that point in time, so July 2013, when did you think that Post Office were first made aware of the Calendar Square book?
Having seen this, I would have assumed it was September. Oh no, he doesn't say that, does he? I don't know.
Did you take any steps to find out?
So I would have expected this to have come out of the inquiry stream that we were running at this time. So when that Friday the 28th had occurred and the two other bugs were mentioned, the first priority as I saw it was, let's understand what the impact is for the criminal cases and the civil cases. And first and foremost, what do we need to do about those? And as part of that, I would have assumed that what would have come out would have been fact-finding around the bugs, and this one as well, as to who knew what when.
And can you recall what the answer to the who knew what when was?
I can't recall, no, I'm sorry.
Did you see any documents that were relevant to when Post Office Limited discovered the Calendar Square book?
I can't recall.
Do you remember how Post Office Limited searched for documents on that issue?
No.
Moving to the receipts and payments mismatch book, do you accept that you were aware in late June 2013, firstly about the receipts and payments mismatch book?
This is one of the ones I would call the 14.
14 book, yeah.
Yes.
Can we turn, please, to poll 20107948? And at the bottom of that page, please, we see an email from Roderick Williams, 1st of July, to you and others. Yes?
Yes.
It refers to a draft briefing note. If you carry on further down, please, to page 4. And to the bottom, please. See an email from Simon Baker, summary of receipts, payments, problems. And the timeline set out, March 2010, first incidents occurred. March 2011, letters sent to branches and corrections made. So at this time, July 2013, you were aware, weren't you, that Post Office Limited had been aware of this receipts and payments mismatch problem by at least March 2011?
Yes, I think at this point this information's coming, yes.
So that was the receipts and payments mismatch, which is 62, I think. Well, we'll look at that, the 14, which I call the suspense account book. In early July 2013, do you accept you were aware that Post Office had knowledge of the suspense book in June 2012?
That's the one we just saw on the...
let's go to the documents. It may be
Thank
easier
you.
that way.
That would
Poll
be easier.
302968, please. Thank you. So we see this is you're the sendee at the top, the sender, sorry, sendee. Dated 4th of July 2013 to Susan Crichton. So we need to keep each other copied in on everything. We say timeline for local suspense problem. If we can go down, please. It says, email from Roderick Williams, here's my summary of my call with Andy Wynne. It says, issue first surface at Post Office Finance Centre on 6th of February 2012, at the close of branch trading period. You see how that was resolved without noting the bug. If we go over the page, please. Sorry, just that's my error, just slightly up. There we go, thank you. On 6th February 2013, the Willand Branch sub-postmaster contacted the MBSC to report the same discrepancy in his branch trading as the previous year. MBSC passed this on to Fujitsu between 6th and 8th February 2013. Fujitsu then notified FSC, that's Post Office Financial Service Centre, isn't it?
I don't know, sorry.
Well, if we look at the top, the first bullet
Oh,
point.
okay, sorry, thank you.
Of the problem on 28th February 2013. So by this point you were aware on this issue, the suspense account issue, Post Office had knowledge of it from the 28th of February 2013.
Yes.
Was this common knowledge at this time in the legal team?
I think it would have been known between the lawyers, Susan Crichton, myself, Mr. Singh and Roderick Williams. This week was a whirlwind, so information was coming in every day. There were briefing notes to be commented on every day. This was a very busy week.
At that point, did you think that there would have been documents relevant to those bugs to which Post Office Limited had access?
I can't recall that specific thought. Our priority was to get the criminal and civil advice to see how we took it forward if there were any issues around the convictions, etc., that were unsafe.
Well, at this point, you're finding out that Post Office had knowledge over a number of years of various 3 bugs, correct?
Yes, I think so.
And you're considering what advice is necessary on civil and criminal,
Yes.
Including criminal convictions.
Yes. We're seeking that advice from the external specialist.
Surely it must have occurred to you that one of those issues would be, well, have we disclosed documents that are relevant to these bugs to people who've been convicted on the basis of Horizon data?
I assume that was part of what the externals were considering and looking at, yes.
But why weren't you considering it?
So I thought it was being dealt with by the externals in conjunction with Mr. Singh and Mr. Williams.
But you're being brought in here, aren't you?
Yes.
And do you accept on its face there's a potential serious disclosure failing here if information about these bugs hadn't been communicated to sub-postmasters who've been convicted on the basis of Horizon data?
And I understood that was the advice we were seeking.
And is your evidence that at that point, it didn't occur to you to look for documents yourself that may be relevant to those bugs?
I can't recall that specific issue.
Do you think you would have thought that? Is it likely that you would have thought that?
It's difficult to say.
Why is it difficult to say?
Because of my lack of knowledge of criminal law.
But standing back, do you need knowledge of criminal law to know that if someone's been convicted on the basis of Horizon data and Post Office is aware or had been aware of bugs in the Horizon system, that it was necessary to disclose documents relevant to that?
I would have expected any direction around that to come from the external advice and say, okay, you need to do X, Y, and Z.
Well, in these discussions at the time, what was anyone saying, we need to look for these documents?
I can't recall that, no.
Can we look, please, at poll 20145-142? So this is your email to Martin Smith and Simon Clark. They're both representatives of Cartwright King.
Yes.
And we see John L. Singh and Susan Crichton and Roderick Williams in copy. You're asking for whether advice had been changed because of a new timeline on the local suspense bug. Sorry, the suspense account bug. You put two questions. The first is, do you still have to look back to cases since it first happened in Jan 2012? We will want you to anyway. Can I just ask you to explain what advice you were seeking in that question?
I can't recall offhand. I must have thought of there was a logical question to be asked, and I asked it.
And you can't assist us further?
It looks like I'm asking about, do we have to go back and review past cases?
At that point, why was January 2012 being picked?
I don't know. I can't recall.
Can you recall whether anyone raised the process going, the review going back to 2005 when the Calendar Square book was identified?
I can't recall, sorry.
You say, number 2, does this mean the only GJ, presumably that's Gareth Jenkins,
I would expect so, yeah.
the only Gareth Jenkins statements that might give concern are ones since February 2013? Do you take it from that at this point you were aware of the advice that was subsequently given in writing by Simon Clark that Gareth Jenkins, in his view, was in breach of his duties as an expert?
I can't recall. I may have gone to that con on the 3rd. I can't recall.
Well, what else would that mean?
I don't know if someone was talking about the statements in a high-level way. I just can't recall, I'm afraid. There's clearly an issue that I've picked up on, but I can't remember any of the detail about it.
We know, as a matter of fact, what happened on the 15th of July. Simon Clark gave advice on Gareth Jenkins in stating he was in breach of his duty as an expert. That was a written advice. Are you aware of anything else that this email could refer to relating to Gareth Jenkins' statements, other than concerns raised by Martin Smith and Simon Clark as to his duties as an expert?
I'm afraid I just couldn't remember, and I couldn't think of anything, but I can't recall with any certainty.
I'm going to put it one final time. Do you accept at this stage, 4th of July 2013, you were aware of the concerns about Gareth Jenkins as an expert and whether he was in breach of his expert duties?
I may have been, but I just cannot recall.
You say Susan and I have to brief the CEO at 9:45.
Mm-hmm.
Can you remember what that briefing was about?
No.
I expect I know the answer to this, but do you remember what you told the CEO and whether you told her anything in relation to Gareth Jenkins?
I'm afraid I don't.
come down, please. Please, could we go to poll 20296821? If we could go, we see there, sorry, your sent this email by Alwyn Lyons on the 28th of June. If we go down slightly, we see FYI summary advice on the impact of Book 14 on Bonus Road, and then back to the top. It says, Alwyn Lyons says, can we call bugs incidents from now, please? From now on, please. Do you remember receiving this email?
I don't remember receiving it, but I do remember some people wanting to use different words for bugs.
What do you remember about that?
I remember thinking at the time it was slightly idiotic in that people would know what was being talked about, so why would you use a different word?
Did you ask for the reasons behind this message?
I can't recall if I did or no.
Was it because people in Post Office wanted to play down the impact of the word bug?
I don't know. It may have been, but I don't know.
Did you follow this advice?
I can't recall personally following it.
Can we please go to poll 20407582? So this is an attendance note with Simon Richardson. Simon Richardson is here Bond Dickinson.
Yes, I think he was one of the senior partners at Bond Dickinson.
So on the 10th of July, you and Susan Crichton are noted to be in attendance. If we could just go down so we can see more of the body of the attendance note, please. Can you remember what the purpose of this conference was?
No.
At 3.
I think it was in the context of I was about to go away for a period of time. And I think there was a challenge because Roderick Williams was due to be away the following week, and Mr. Singh, I believe.
And so why was that relevant to the conference?
So I think the genesis of the conference might be Susan Crichton seeking a degree of high-level support from Bond Dickinson at that point.
At 3, we see it says the board want to sack SS. Does that refer to Second Sight?
I believe so, yes.
And of course are now not coping well with the fact that they are independent. Susan Crichton is going to arrange to meet Second Sight, and she asked if she could use our offices next Tuesday. What was the discussion on, well, no, let's start first. Does the board refer to the Board of Post Office Limited?
I believe so, yes.
And what can you recall about this discussion?
I can't recall anything specifically about this discussion.
It's quite significant, isn't it, the board saying they want to sack Second Sight?
I remember that particular thought being mentioned, probably by Susan Crichton, at some point in these 2 weeks. Because I was surprised because I'd always thought Second Sight was the way to go. So I wasn't persuaded by those floodgate arguments, etc., back in the previous summer when they were appointed. And I thought once you had appointed them and signed up to an independent review, then there was always the chance that you would get an answer that wasn't an answer you were expecting. So to have a reaction suggested by, somebody's view was sack Second Sight, that seemed to be slightly odd because that would be a very public event.
Well, if you thought it was slightly odd, did you ask, you said you thought it may have been Susan Crichton, did you ask her why they wanted to sack them?
I may have done, but I can't remember when sacking them was first mentioned.
Well, this was a attendance note of the 10th of July 2013, so it's mentioned by that point.
Yes, yeah.
Do you recall why, or any reasons, were there any reasons given as to why it was said the board wanted to sack Second Side?
No, I can't recall any specific conversation or explanation of reasons.
Just before we take the break, you've referred to you were about to go away for a period of time, and in your witness statement you say that was for a sabbatical.
Yes. Yeah.
When was it arranged that you would go on the sabbatical?
Probably the previous year, because it was driven. My wife had a sabbatical at her place of work.
So it's not unconnected to...
Totally unconnected.
So that's probably a good time to take the second morning break. If we could come back at 12:10.
Yeah, okay, but we're going to finish this witness this morning, I take it.
Yes, absolutely. I have not many more questions.
Fine. No, that's fine, Mr. Stevens. Okay.
Thank you, sir. Good afternoon, sir. Can you see and hear me?
Yes, I can, thanks.
Okay, I'll carry on. I went earlier to your knowledge of Gareth Jenkins and the advice of Simon Clark that he was in breach of his expert duties. I asked you by 4th of July 2013, were you aware of that? And you said you couldn't recall. Do you now have a positive recollection as to when you first became aware of those issues?
Not a precise positive recollection, no, sorry.
Can we turn to poll 3060681, please? So this is an email from you to Will Gibson on the 9th of July 2013, and it says next to Will Gibson's name SHEX or SHEX. That's the shareholder executive.
Yes, that's the department, the BIS government department that's responsible for the post office.
So effectively the agency that oversaw the Crown's shareholding interest in post office. Did you often report to people at shareholder executive?
No, by exception.
You say urgent will, intel on MP cases, JFSA case, intel to follow, and you set out a matter on the Misra case. Do you remember why you were asked to provide this information?
No, it may have been, given it was Shex and Will Gibson, it may have been that some information needed to be given to a government minister.
Would you have put this together yourself, or would you have relied on other people?
Absolutely not. This would have come from Mr. Singh.
Mr. Singh?
Yeah.
And would it have come from... would you have taken any advice from Cartwright King as well?
I can't recall. I think it might be Mr. Singh because also he is copied in on the email.
It says, Misra case, defendant pleaded not guilty to theft, but pleaded guilty to false accounting. Defendant produced computer expert to argue Horizon issues. Post office used Fujitsu expert to argue Horizon issues. Outcome, found guilty by jury of theft after a 7-day trial. Evidence relied to convict. She alleged it was either Horizon Computer or employees. She said after she had got rid of employees, the loss got worse. Therefore, she blamed Horizon (brackets) at a late stage in proceedings after it was listed for trial. So this trial got adjourned whilst each side got Horizon evidence together. It was a jury trial, so no explanation as to what evidence was relied on by them re-conviction. Why didn't you refer to the advice that had been given about Gareth Jenkins, that he was in breach of his duties as an expert?
I can't recall. I know this would have been provided by Mr. Singh, and I would have been relying on him to give me the correct picture.
I know you say you can't recall when you became aware of the allegations about Gareth Jenkins. If you were aware of those matters at the time you sent this email, do you accept you should have included it in this email?
I wouldn't have necessarily assumed that, because something around that might have been dealt with by Susan Crichton at that level with Shex.
Would you, on the basis that you're aware of the issues to do with with Gareth Jenkins, this summary of the Misra case isn't a full and fair description of the issues Post Office Limited was facing in relation to this Misra case, was it?
Sorry, I think the context of this email was that an urgent turnaround on it was needed, and I think it's done in a matter of minutes if you look at the timing.
Well,
so
it wouldn't take you long, would it, to write, we have advised that the expert evidence in this trial was provided by an expert who has been in breach of his duties.
I agree with you, but I can't recall at the time whether I took the point or not.
Well, you didn't you didn't raise the point, did you?
I didn't raise the point because it's not on that email, no.
And the issue is why? Do you know why?
I can't recall at the time.
Can you think of a good reason why you didn't?
I'm sorry, I can't.
Would you accept that it's a failing not to have referred to it?
I don't know if it's a failing because I don't know if that information was being separately communicated to Shex.
Well, would it be incumbent on you to check if it was being separately communicated to Shex?
So if you see, I've also copied in Susan Crichton and Olwen Lyons.
Did you take steps with them to see that they were communicating the issues with Gareth Jenkins to shareholder executive?
I may have done, but I can't honestly recall.
I think you told me that this email was either drafted by, these are my words, not yours, so let's see if I've got it right. It was either actually drafted for you by Mr. Singh or the information came from Mr. Singh.
I think
so. If Mr. Singh knew of the advice about Gareth Jenkins, have you got a view about whether he should have included it or told you about it?
If he knew about it and he thought it was pertinent from the criminal perspective, then yes, I suppose he should have put it on the email.
And Ms. Crichton, Ms. Lyons were copied into this email, and if they knew of Mr. Jenkins's, the advice about Mr. Jenkins, should they have in some way intervened to ensure that the shareholder was given that information?
I would have expected them to, which is probably why I've included them on copy in the email.
So one way or another, it seems to me that you are accepting that the shareholder should have been told about the information, assuming that any of these people knew about it, and you didn't tell him either because you didn't know or you assumed that one of those would tell him. Is that it in a nutshell?
I think that's probably it in a nutshell, sir.
Right, fine.
Thank you. So that document can come down. Before you went on your sabbatical,
Yes.
were you, did anyone raise a concern about how Gareth Jenkins had been instructed, namely whether he'd been advised of his duties as an expert?
I can't recall specifically that matter being raised. That's not to say it wasn't discussed by someone, but I can't recall it.
Can you recall whether there was any investigation into the manner in which Gareth Jenkins had been instructed by the Post Office Limited Criminal Law Department?
I can't recall that during those July weeks in the run-up to the sabbatical.
Did you discuss this with John L. Singh at all?
I can't remember if I discussed it with him or not.
Would you accept that it was important for the Post Office Legal Department to examine how Mr. Jenkins had been instructed and whether he'd been instructed properly?
Yes, I would.
And who do you say was responsible for that?
So I was going on sabbatical, and I would have thought an issue like that would have been dealt with by Susan Crichton with support from Mr. Singh or Mr. Williams.
The advice on the advice on Gareth Jenkins dated 15th of July, I can bring it up if it assists. Do you recall reading it?
I recall I might have read it when I came back from sabbatical.
You say you might have.
I can't recall specifically, but it would be likely I would have read it when I came back from sabbatical.
And did you, when you read it, check whether any steps had been taken to examine how Mr. Jenkins had been instructed?
So I remember having conversations with Susan Crichton when I came back, and it was, I think, on the cusp of her resigning, around in the wake of her resigning, I suppose, what matters needed addressing, and I can't recall that being on a live list of matters as a point to be resolved.
Did you read the 2nd of August? I can show it if you need. The 2nd of August advice by Simon Clark regarding allegations that documents had been shredded.
I can remember, I think, seeing that when I returned from sabbatical.
Presumably that came as a
That was quite a,
significant surprise.
yes.
What steps did you take, if any, to see whether those matters had been investigated?
So I remember having conversation, it might have been with Mr. Singh, it might have been with Susan Crichton, because I saw Susan Crichton, the correspondence that related to that subsequently. And I have a vague recollection that it was described as a dealt with matter, and in fact there hadn't been any document destruction. But that's a vague recollection only.
I want to cover one final topic before there will be some co-participant questions, which I anticipate will take us to lunch. Could we please bring up poll 20192214? Thank you. Could we go to the bottom of page 3, please? Sorry, the bottom of page... Oh, no, yes, bottom of page 3. So we see discusses a letter received from the CCRC, from Susan Crichton, I should say, sorry, during copy. And it says, their advice feels odd to me, as if given on a take it or leave it basis, and I'm not comfortable that's particularly useful in this context. Could we discuss, I'm happy to go to another firm that specialises in criminal law, or a barrister. Somehow it feels as if there is a conflict here, which I'm not sure I understand. Do you recall there being any conversation about whether or not Cartwright King had a conflict of interest in overseeing matters related to the CCRC and the review of past convictions?
No, I don't.
You were copied into this email. Did you not discuss this with Susan Crichton at the time?
No, because I think by this stage I had left and I was on sabbatical. I think I went on sabbatical Friday the 12th.
So you can't assist at all with any discussions on...
Sorry?
You can't assist at all with discussions on a potential conflict of interest?
No, I don't think I was... I know there are occasions where I'm on sabbatical and I respond to emails, and there's one mention of me doing a call with Beechcrofts over finding out, but other than that, I can't recall being on any phone calls or any discussions whatsoever.
Thank you. That's all the questions I have, sir. We have questions from 3 sets of core participants. I understand there's the recognised legal representative for Gareth Jenkins, who has given a time estimate of 20 to 25 minutes. Mr. Henry, I think, said 10 minutes, and Mr. Jacobs says 5 minutes.
Well, we better crack on because they're all going to finish by 1 o'clock, Mr. Stevens.
Yes, I was going to say the same. So I'm in your hands. Would you...
Let's have the 2 short ones first, and please stick to the shortness of the questioning that you predicted?
Yes, so on that basis, then it'll be Mr. Jacobs first.
Fine.
Mr. Flemington, I represent a large number of sub-postmasters. Could we go very quickly to POL 001-43379? It's an email from Jarnail Singh to yourself, dated the 16th of July 2012, and you deal with it at paragraph 88 of your witness statement, so we know you've seen it. This was an email chain in light of Henry Bowyer's advice, dated the 11th of July, when he talks about what's been described as a floodgates issue. And there was severe recriminations for the business if Second Sight uncovered any systemic problems. I think you dealt with that with Mr. Stevens at 11 o'clock this morning, yes?
Yes.
So what we have here is Mr. Singh saying, and if we could scroll down to the 6th line, all this will mean we have to provide extra evidence as defence would put us to proof as to systems integrity. Also increase in vast disclosure requests, cases being transformed from general deficiency trials into boundless inquiry into Horizon system. This would mean vast scope of disclosure requests. Tasks would be close to overwhelming. Only way to comply with prosecution disclosure obligations would be to instruct an expert at Fujitsu. And then he talks about sticking points. Sticking points in disclosure process would be costs of obtained Horizon data. Transaction logs would be obtained from Fujitsu that show the details of every single transaction at a post office. Then he goes on to talk about costs. For example, a defence request could be for logs from 6 months prior to defendant's tenure to the present time, and costs of obtaining that data would frankly be astronomical. It is expensive to obtain this material because expense simply comes from post office's contractual obligations to Fujitsu. So he's talking about the contract. For example, to obtain 6 months data would cost £20,000, and mountain of information costing more than covering more than 5 years would cost ? So what we have here is the head of criminal law at Post Office saying that because of the contract with Fujitsu, there is a bar to compliance with disclosure obligations in criminal cases because the costs are untenable or unaffordable. Do you accept that? That's what he's effectively saying, Mr. Flemington.
I think he's saying that the costs are high or significant. My reaction to that would have been that this shouldn't be driven by cost.
Yeah. It's Mr. Singh's concerns, though, that the floodgate point that Mr. Bowyer raises would have an impact on ability to comply with disclosure. Do you accept that?
I suppose in one sense he's saying the floodgates would be very, very costly. And the way I would have looked at this would have been to say, well, there might technically be a limit on costs, etc., but everything on the commercial side would be up for renegotiation.
Didn't this put you on notice, Mr. Flemington, that there was a concern that Post Office had not been complying with their disclosure obligations in criminal cases where Horizon issues were raised because of the contractual issue with Fujitsu, because of the cost of providing that information?
I don't recall making that conclusion.
Because the implication from Mr. Singh is, well, we can't afford to provide this disclosure in criminal cases because it's too expensive, and let's just hope that somehow Post Office can muddle through. Isn't that something that's quite worrying when you're thinking about criminal prosecutions and disclosure and how important disclosure is?
So my view would have been that cost would not be a restriction on us complying with our legal obligations. How could it be?
Did you respond to Mr. Singh and say, no, absolutely not, this cannot be the Post Office's approach?
I can't recall, I'm afraid.
Did you speak to anyone about it?
It's likely I would have spoken to Susan Crichton about it.
And was the matter ever resolved between Post Office and Fujitsu? Are you aware that of any meetings where it was said, we simply can't afford to be bled dry in this way because we have absolute disclosure obligations in criminal cases?
I think there may have been discussions with Fujitsu around assistance for disclosure obligations. I can't recall when those would have been, but they may have been 2012, 2013.
And did you make any inquiries as to whether this had been a problem or an issue with disclosure in past criminal prosecutions, such that they might be unsafe?
I can't recall that.
And why not, given what Mr.
Sorry, I
said?
simply can't remember.
Okay, very well. I don't have any further questions. Thank you.
Thank you.
Thank you, Mr. Jacobs. Is it Mr. Henry or Miss Page?
Mr. Henry.
Right.
Mr. Flemington, if it were to be suggested that your evidence is a sustained study in accountability, what would you say?
I've tried to answer the question, sir, to the best of my recollection.
I want to pick up on what Mr. Jacobs has said, and you saying that you would have given unequivocal advice that costs shouldn't enter into the issue concerning data. Do you remember? You've just...
Yes.
Yeah. Could we go, please, to POL 001 43384. And could we go down, please, to, well, we can see, do you think we should invite Simon Baker to the call? So that's the company secretary asking for your opinion on that. So you're clearly, being consulted by the company secretary as to whether Mr. Baker should be involved, correct?
Yes.
Go down, please, to your email, and that is 16th of July, 2012. And this, of course, is in the aftermath of Second Sight. And it looks like full steam ahead for the Post Office, doesn't it? Assume your recommendation hasn't changed and is still to keep fighting any such application. That would be an abuse of process application. Issues appear to be comms brief needed to rebut the myths, untrue reporting about Second Sight review, clarity regarding Second Sight's terms of reference, timetable, etc., a plan Bible of what information we're going to provide our legal teams with and the courts if we have to fight applications to stay, plan to deal with disclosure requests, e.g. how we balance obtaining transaction logs and other Horizon data alongside the costs of doing so. Do you want to reflect on the answer you gave to Mr. Jacobs?
So point 4 is about, in terms of doing sensible budgeting. And it's basically saying that we would have to be able to find the money to do these activities.
Well, it doesn't actually say that, does it? How we balance obtaining transaction logs.
I think it's a poor choice of words by me because I think it's ambiguous. But
they are your words, Mr. Flemington.
And I agree. But the sentiment of them was that we were going to have budgeting issues in order to find the money to do this.
You seem to be quite involved in criminal law for somebody who said that you weren't involved in criminal law at all. What do you have to say to that?
I found myself getting drawn into these matters occasionally and sporadically, and I would always try to progress the matter in good faith where I could, but where I couldn't, I would escalate up to Susan Crichton.
I want to go back now to October 2010, and no need to get it up on the screen because you'll remember the emails from Mandy Tolbert. But just before the Seema Misra trial begins, you're contacted by her in an attempt to arrange, and I quote, a conference call to discuss how we deal with these cases going forward, possibly on the 20th of October, as by then I anticipate that Misra will have concluded. And then on the 21st of October 2010, when the jury was out in Mrs. Misra's case, Mrs. Mandy Tolbert sent you another email, a second attempt at organising a conference, and you're first on the distribution list. Your evidence, as I understand it, is that you're accidentally drawn into those emails? Because really it's nothing to do with you.
So if I was drawn into things such as the conference about Second Sight or the Wiley emails or the like, it wasn't at my choosing, it wasn't at my control. And at that point, I thought, I will try to progress matters as best I can. And where I can't, I will escalate them.
May I make a suggestion? These cases concerning Horizon that Mandy Tolbert was involving you in October 2010 reflected the Post Office's policy of bringing test cases. And of course, nobody knew what the outcome of the Horizon, what the outcome of the MISRA trial would be. And you were involved in this to, as it were, deal with policy. Because what would have happened if, for example, Seema Misra's case had ended in an acquittal? You would have had to have been involved in dealing with the aftermath of that, consistent with your responsibility.
So there's two things I'd like to say to that. So one is I can't recall any meetings ever happening on that and that particular work strand going forward. And secondly, this probably was in the context of separation and the fact that actually Mandy Tolbert was thinking in terms of eventually Royal Mail Civil Litigation won't be doing these cases and will hand over conduct of them to Post Office. So I can't recall, but I think it's likely she was starting to think about planning that transition over.
I suggest that's a rationalisation. And of course, it would have absolutely nothing to do, that answer, with your receipt of the Horizon bandwagon email, would it?
I believe
later that afternoon.
Yep, no, I quite remember the email you're talking about because that was the one where I thought the language was not good.
Inappropriate.
Yes.
Right.
But there was a point, I think there was another email, not in my bundle, but someone else's, where there's a thank you for involvement on MISRA, and I think I might have been on that. And I remember contacting the person who sent it and said, thank you for the sentiment, but I'm absolutely not involved in the MISRA case.
And you say that, but of course in July 2013, as we saw from Mr. Stevens' last questions to you, there's the Will Gibson email just after the second break, and you say that was drafted by John L. Singh.
Yes, sir.
So why do you copy him into it if he's drafted it?
Because if Mr. Gibson had any further follow-up questions, he could go to Mr. Singh.
I see. I want to go to one final document, please. POL 000 31352. And that is sent on the 1st of July, and it's discuss of defect in Horizon in court, Seema Misra and Lee Castleton. By that stage, you were aware, were you not, of the difficulties with Gareth Jenkins?
I can't recall.
You can't recall? Well, you were shortly aware thereafter, your answers to Mr. Stevens about the difficulties with Gareth Jenkins.
There would have been some point at which Gareth Jenkins as an issue was flagged during those 2 weeks in July, but I cannot recall precisely when.
I mean, it's clear you're the first recipient of this, together with the company secretary, also the chief information officer, Leslie J. Sewell. It's clear that Gareth Jenkins is the linchpin of your defence in Horizon, and then he was, to your knowledge, damaged goods. Why wasn't the CCRC immediately informed of this, Mr. Flemington?
I wouldn't have the knowledge to know to inform them. and I would be relying on Mr. Singh and Cartwright King to flag that.
Is that your evidence, Mr. Flemington, that you wouldn't have appreciated what you, as head of the legal department, ought to have urgently tabled for discussion?
I was surrounded by other lawyers and expert advisors and external counsel, and I cannot recall that point as an urgent matter being highlighted at all.
So this all becomes, does it not, part of a picture of mutually delegated irresponsibility? Somebody else is dealing with it.
No, sir, we are trying to take advice, taking advice and acting on it in good faith.
Thank you, Mr. Flemington.
Thank you, Mr. Henry. So is it Miss Dobbin or Miss Oliver?
Actually, just to interrupt, there's one point I think I must clarify now arising from those questions. It's an answer that Mr. Flemington gave on the live note, page 95, line 18, Mr. Flemington.
Yes.
You said, but there was a point, I think there was another email, not in my bundle, but someone else's, where there's a thank you for involvement on MISRA, and I think I might have been on that, and I remember contacting the person who sent it and said, thank you for the sentiment, but I'm absolutely not involved in the MISRA case.
Yes.
Can I just check what bundle are you referring to?
Not in my bundle, sorry.
Yes, but you say, I think there was another email, not in my bundle, but someone else's.
I can't recall.
Have you read someone else's bundle of documents for these inquiry proceedings?
No, I haven't. I will have seen something on one of the publicly available live feeds.
Thank you. So that was the simple point of clarification I needed to make.
Fine. Okay. Next, please.
Thank you, sir. It's Miss Oliver today.
Yeah, I can see that now. Yeah.
Thank you. Good afternoon, Mr. Flemington. I ask questions on behalf of Gareth Jenkins. You've said that you have no criminal litigation experience.
Correct.
And the thrust of your evidence has been that you left supervision of Jarnail Singh largely to Susan Crichton.
I didn't leave supervision to Susan Crichton. Susan Crichton was the GC, and that is the way she organised the department setup. She said at the outset, you won't be supervising criminal litigation or civil litigation, I will do that.
And you've said that you were not aware of whether Miss Crichton had herself any experience in criminal litigation.
Correct.
Did you consider that to be appropriate, that there was one lawyer in Pol responsible for the prosecution of sub-postmasters, but who was in effect working unsupervised by anyone with criminal litigation experience?
So that was the way it was dictated to me that it would be set up. I had asked before separation, would we go and recruit a criminal lawyer, and was told no, that it had been agreed at, quotes, a high level, that one lawyer was enough and that they were being transferred over from the criminal law department.
Do you agree that that made Pol Legal significantly reliant on the expertise and competence of Mr. Singh?
To a degree, but you have to consider that we also had Cartwright King and subsequently Brian Altman reviewing the work of Cartwright King, if you will. And there was no restraint or limit on how much Cartwright King could be used or deployed in the business in relation to the criminal prosecutions.
When criminal prosecutions came within your purview as head of legal, did you take any steps to understand or familiarise yourself with any of the criminal law upon which Pol brought those prosecutions?
So I would not say that they came within my purview. They were always to be supervised and within the purview of Susan Crichton.
When they came within your team then, did you take any steps to understand or familiarise yourself with any of the criminal law that was applicable?
I did get an initial briefing from Jarnail Singh on the overarching aspects of the criminal law in relation to the poll prosecutions. But again, I was not responsible for the carriage of those prosecutions or the supervision of Mr. Singh.
Did you ever review the poll prosecution files or dip sample the prosecutions that were being conducted?
No, I did not.
And in relation to Cartwright King then, did Poll have any arrangements for reviewing their work or sampling the files on cases that they were responsible for prosecuting?
I can't recall the specific provisions of their retainer and their engagement letter.
All right. Can we turn then, please, to the Simon Clarke advice? Do you recall that that was sent to you on the 17th of July of 2013?
I don't recall off the top of my head, no, but...
Do you think that sounds about right, or would you like to go to the email?
May we go to the email, please?
Of course.
Sorry.
It's Paul 00192249, please. Thank you. If we can go down to the third email, please. So this is an email from Martin Smith to Susan Crichton, copying you. Susan, please find attached Simon Clarke's advice concerning Gareth Jenkins. Kind regards, Martin. Do you recall receiving that on the 17th of July?
I don't know, because I don't recall receiving it, sorry. I was on sabbatical by then.
Do you agree that during the course of your sabbatical, you continued to engage with emails that were sent during that time?
Very occasionally. I'd been given a specific lecture by Miss Crichton to try and not look at the BlackBerry, because I'd already been raising issues about splitting up my role.
We can go to some examples if necessary, but do you agree that those emails that you did engage with involved correspondence with Susan Crichton, Jarnell Singh, Roderick Williams, lawyers from Bond Dickinson, lawyers from Cartwright King?
I think there were about 3 or 4 emails from my recollection.
And do you recall that they concerned topics such as the review of criminal cases, questions of disclosure, the instruction of the criminal QC?
Yes, they may have done.
You respond to one of those email threads on the 17th of July. Do you think that makes it more likely that you would have seen the Simon Clarke advice at the time it was sent to you?
Not necessarily, because I tell you why very specifically, in that I hated reading attachments on the BlackBerry. I would read cover notes, but attachments I found difficult to see with eyesight. So for that reason, I would tend not to read attachments. In terms of the content of those other emails, there's a possibility I was at the con on the 3rd of July, and that matters got mentioned out of those. It's possible matters got mentioned out of other discussions that happened in those first 2 weeks when I was in the office. But I can't, hand on heart, specifically recall seeing the printed advice at this time.
All right. In terms of the substance of those discussions then, can we please go to poll 00407 please? Thank you. This is the attendance note that you've already been taken to. Yes. Of a conference at Bond Dickinson that you attended with Susan Crichton. It starts by saying, I had some time with HF, presumably that's you,
yes, before
Susan Crichton joined us, and there was a discussion about Cartwright King and Rob Wilson. If we go down then, please, to point 6. And here it's recorded The real worry was around the Fujitsu expert who appeared to have known of some of the problems, but not referred to them in his report or statement, even though they could be dismissed. There are non-disclosure issues here. They are looking at replacing that expert with somebody else. Do you recall that being a feature of the discussion?
I don't recall it specifically.
Do you agree that that seems to indicate that even if the Simon Clarke advice was something you didn't engage with during your sabbatical, you must have been aware that there was a real worry within Pol about Mr. Jenkins' statements being used in previous prosecutions, that these concerns related to non-disclosure of the bugs revealed to Second Sight, and that there was an understanding that he could not be used as an expert in prosecutions going forward?
It's possible, yes, but I would have expected that Susan Crichton was then dealing with that.
You've agreed with questions from counsel to the inquiry that once knowledge of those concerns came to Pol, it would be very important for the Post Office to understand how Mr. Jenkins had been instructed. Do you remember giving that evidence?
I don't, but yes, if you...
And your evidence is that you would have expected Miss Crichton to do that, is that right?
Yes.
Did you take any steps to understand what investigation she had undertaken or what she had learned of those features?
I can't recall that being discussed when I came back. That's not to say it wasn't.
Did you, before you left or when you came back, ever ask to see any instructions which Pol or Cartwright King had provided to Mr. Jenkins?
I can't recall, sorry.
You've said you can't remember speaking to Mr. Singh about how he instructed Mr. Jenkins. Do you remember speaking to the external lawyers at Cartwright King about whether Mr. Jenkins had been instructed about his expert duties of disclosure?
I don't specifically remember, no.
Did the issues that were being raised about Mr. Jenkins by Cartwright King before and after the publication of the written advice by Simon Clarke give rise to any concern on your part that they might be indicative of broader prosecutorial failings on the part of Pol?
No.
Do you think that was an oversight on your part?
No, I just wouldn't have... I don't think I would have thought about the point.
Were you aware of the obligations that Pol held in relation to how they handled expert evidence in the course of criminal prosecutions?
So that's why I felt we were taking expert advice from Cartwright King at this point, that any issues like this would be flushed out and then could be addressed.
Did you ever consider that an appropriate course might be to speak to Mr. Jenkins in order to understand the circumstances in which he came to give evidence in these cases?
Again, I suppose I would have thought that Susan Crichton was dealing with that. This was surfacing just before I was going away, and she would have had conduct of it for the next 6 weeks.
Can we go to Pol 00193-383, please? Thank you. If we can go to the third email down, please. So this is an email from Roderick Williams to Leslie Sewell, copying Susan Crichton, Simon Baker, and yourself. It attaches 2 draft documents addressed to Fujitsu, which Mr. Williams said were to put us on the record with Fujitsu about the issues raised in Second Sight's interim report. One is described as a shot across the bow, the other as a letter of claim. Despite this being during the period of your sabbatical, do you agree that you appear to reply on the same day to ask whether the draft documents have been discussed within legal? That's the next email up, if we can scroll up, please.
Yes, I do.
And if we can please go to one of the attachments, which is Pol 00140-620. and page 2, please, paragraph 4. Thank you. We see there that it said, Post Office was therefore disappointed to discover that witness evidence prepared by Fujitsu may not have been fully disclosing historic, albeit known and resolved defects. This has led to Post Office having to review all its historic criminal prosecutions for the last 3 years to ensure that it has not breached its duties of disclosure under the criminal court rules. Do you agree that your email that we just looked at rather suggests that this was an attachment that you would have opened?
I honestly didn't look at attachments, and so I wouldn't have opened and seen this.
Is it something that you looked at when you returned to Pol after your period of sabbatical?
I remember speaking to Susan Crichton when I returned, and because in the context she was resigning, there was very quickly activity around dividing up matters and responsibility for matters. And I cannot remember this being assigned to me in terms of progressing, that if it was to be progressed, it was being progressed by someone else, but I can't honestly remember.
Can you recall any discussion at all as to whether to write to Fujitsu in these terms?
No, I can't.
And what decision was ultimately made in that regard?
I can't recall anything in relation to that, sorry.
Thank you. One final document from me, please. It's Pol 001 55555. This is a handwritten note. We know that it was authored by Roderick Williams. The date of the note at the top right-hand corner appears to be the 2nd of September 2013, which was the Monday before you, in your statement, say that you returned from your sabbatical. You returned on the 3rd of September. Is that right?
I think I may have returned on the 2nd.
2nd. All right. So you returned on the very day that this note
Yes.
appears to have been authored?
Yes.
The note refers to conversations with Martin Smith of Cartwright King. If we can please go down to the bottom of page 1. Do you see in the right-hand box the question, what were we doing to instruct GJ?
Yes.
Do you understand that that's likely to be a
Yes.
reference to Mr. Jenkins? And then in the left-hand list, first arrow point down, don't think he's ever been advised of his duties. Do you see that?
Yes.
Were the contents of this note ever discussed between you and Mr. Williams?
I can't recall discussing this at all.
Can you recall whether it was known within Pol by September of 2013 that Pol had failed to instruct Mr. Jenkins as an expert witness in his expert duties, or that there was at least a very serious question as to whether it had ever instructed him in that way?
I would have probably known of the issue per se, but I can't recall what level of knowledge there was across Pol, if that was your question, sorry.
Well, would you have regarded it as significant information that you ought to have been told the contents of this note?
Yes.
And do you know whether it was for this reason that a draft letter of claim was not sent to Fujitsu?
No, I don't know.
Do you recognise that Pol's failure referred to in this note to instruct Mr. Jenkins in his expert duties and in accordance with their legal duties was an exceptionally serious matter because it gave rise to real questions about the basic competency of its prosecutors?
So obviously it's not my note, I didn't author it. And I can see there it's talking about raising questions of what were we doing and don't think, but I don't see it's conclusively coming to a conclusion that there is an issue there.
do you think that the question or the serious question over whether Mr Jenkins had been advised of his expert duties is something that Poll ought to have treated with the utmost seriousness?
Yes, but if I look at this note, the issue is being thought about and worked on and discussed.
Thank you. Those are my questions.
Well, that's extremely good timing. So my gratitude to the representatives of the core participants who have tailored their questions to finish promptly at 1 o'clock. So thank you, Mr. Flemington, for coming to give evidence and providing a witness statement. I'm grateful for your participation in the inquiry.
Thank you,
Mr.
sir.
Stevens, 2 o'clock?
Yes, sir.
Right.
So may I just make one point?
Yeah.
Which was I had agreed with Mr Stevens at the start that I would actually like to have said some words at the start to
Right.
express how
then
sorry I
please-
was.
Well, please say what you wish to know.
Thank
That's
you.
fine.
So I just wanted to say how sorry personally I felt for all the pain and suffering that has been caused by this scandal to all the people who have suffered. And I hope today that in some small way my witness appearance will help the inquiry establish lessons learned.
Thank you, Mr. Flemington. All right, we'll start again at 2 o'clock.
Thank you, sir.
Good afternoon, sir. Can you see and hear us?
Yes, thank you.
May we please call Mr. Bowyer?
Mm-hmm.
I do solemnly,
I do solemnly,
sincerely and truly
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Could you confirm your full name, please, Mr. Bowyer?
Yeah, it's Harry Bowyer.
Thank you for coming to the inquiry to assist it in its work. As you know, my name is Emma Price and I will be asking you questions on behalf of the inquiry. You should have a hard copy of a witness statement provided by you to the inquiry in front of you. Do you have that?
I have that.
It is dated the 2nd of April 2024. And if you turn to page 32 of that, please. Does your copy have a visible signature?
It does.
Is that your signature?
It is my signature.
I understand there is a correction to the statement you'd like to make. Is that right?
Yes. I stated paragraphs 26 and 69 that I wasn't aware of the back door into the Horizon system until the Deloitte report. I've seen emails since which show that I was told about it in November 2012.
With that correction made, are the contents of that statement true to the best of your knowledge and belief?
To the best of my knowledge and belief.
That statement, for which the reference is WITN 109-90100, is now in evidence and will be published on the inquiry's website in due course. Starting, please, with your professional background. You joined Cartwright King Solicitors in the summer of 2008, is that right?
That's correct.
Having been in practice at the independent bar before that since 1990?
Yes.
Your practice at the independent bar had been exclusively criminal?
Exclusively criminal.
And you had been involved in both prosecution and defence work?
Indeed.
You say in your statement that when you joined Cartwright King, you were the first employed barrister in the firm, is that right?
Yes, it was.
But in the few years which followed, the firm expanded their advocacy department by employing a large number of barristers and solicitors with higher rights to cover almost the entirety of their Crown Court work.
That's correct.
Could we have on screen, please, paragraph 5 of Mr. Bowyer's statement? That's page 2. At paragraph 5, you say this: when I joined Cartwright King, they had 3 offices, Nottingham, Derby and Leicester. They embarked on a period of rapid expansion by acquiring other firms of solicitors. At their peak, they had around 20 offices from London to Newcastle. This involved a great deal of fairly ruthless reorganisation as they cut away the dead wood. Thinking back to the rapid expansion which took place, was the reason behind this that it would enable Cartwright King to prosecute post office cases in-house?
No.
No.
No, the expansion was at the time there was a proposal that legal aid firms would be limited to a very few in each legal aid area. And so what they were trying to do was put themselves in as many legal areas so they could bid for the contracts.
Did the fairly ruthless reorganisation you refer to have any impact on the post-office work which was being done at the time by the advocacy department?
I don't think so.
That can come down, thank you. Did members of the advocacy department prosecute post office cases in both the Magistrates' Court and the Crown Court?
There was quite a lot of work that was prosecuted in the Magistrates' Court and the Crown Court, but most of the Crown Court work went out to external counsel.
The advocacy department was based in the Nottingham office, is that right?
That's correct.
The head of department was initially one of the equity partners, Steve Gelsthorpe.
That's correct.
And then Andy.
That's right.
You say in your statement that it was Andy Cash who introduced the then Royal Mail Group work to Cartwright King.
That's right.
And he was based in the Derby office but spent more time in the Nottingham office when he became head of the advocacy department.
That's correct.
Was there any provision at Cartwright King for training in relation to private prosecutions, and in particular prosecution disclosure obligations in private prosecutions?
There was very little.
Very little as in none, or?
Well, as far as I was concerned, the private prosecutions that they did was the Royal Mail work initially. They did some RSPCA work. And then Andy Cash brought in the poll work, I think, around about 2012. But as far as actual training is concerned, I certainly wasn't trained. And I don't know what happened to those who were doing the poll work, because it was being done in other offices apart from mine.
What were you told when you were first introduced to the Royal Mail Group and then later Post Office Limited work about the basis on which prosecutions were brought by the Post Office and the history of this?
I'm not sure I was told very much at all.
You were aware, though, that the Post Office was bringing private prosecutions.
Oh,
and that was
absolutely,
the work
yes.
that you were doing.
Yes.
At the time, did you recognise any risk arising from the Post Office being simultaneously victim, investigator and prosecutor?
Well, at the time, I wasn't really involved with it. If I'd addressed my mind to it, then yes, I probably would have seen the difficulties that you put forward. But the Post Office work that the Royal Mail Group work initially tended to be postmasters or Royal Mail workers who were stealing from the post. And then in due course, the poll work was the work that this inquiry is in fact looking into. But as far as I was concerned, I didn't do very much of it at all until Andy Cash came into the advocacy department. And then he started to pick the brains of the various advocates there about various issues and would ask us to write the odd advice, charging advice, etc.
You address at paragraph 31 of your statement the training you received on the Horizon system. Can you help with when you received this training? Do look to the statement if you need to.
I can't recall. I think it would have been about 2012.
And you say that training did not cover the reconciliation of balances. What did it cover? Can you recall?
Well, I can't remember where it was. It was somewhere up north. But they had a Horizon system, and effectively myself and a number of external counsel were actually shown how the system worked effectively from a cashier's point of view.
Were members of the advocacy department responsible for keeping up to date with their own continuing professional development obligations?
To an extent, yes.
Was there any oversight of that by the
Yes,
firm?
there was. You had to show that you'd done your CPC.
You say in your statement that you were made a director of Cartwright King during the period covered by the inquiry.
Yes.
Can you recall when it was that you became a director?
I can't, I'm afraid.
You say you were one of around 30 directors. What responsibilities did you have as a director over and above those as a member of the advocacy department?
There were various responsibilities. File reviews was one of the main ones, so we had to review the files of other people in the department.
But you say you held no equity in the firm, is that
No.
right?
No, it was more of a reward that came up with the rations rather than a pay rise.
And you resigned from Cartwright King in December 2015, is
That's
that
right.
right? And what was the reason for your resignation?
Myself, Martin Smith, and Simon Clark wanted to set up our own business.
Is that something you went on to do?
That's something we went on to do.
Turning, please, to your involvement in the Royal Mail Group and later Post Office Limited work, and dealing first with the period prior to the interim Second Sight report coming to your attention in 2013. Could we have paragraph 8 of Mr. Bowyer's statement on screen, please? That is page 2. In the last line on this page, you say the RMG work was more provincial at that stage, but in 2012, Andy Cash brought the poll work into the firm, which was nationwide in nature. You say that the post office work was nationwide. Can you help with the scope of Cartwright King's instruction to act for the post office, and in particular, whether the general instruction of Cartwright King covered criminal cases in Scotland and Northern Ireland?
The answer is I can't help with that very much. We didn't tend to do Scotland and Northern Ireland. That was outsourced to other solicitors. Obviously, you've got the Scottish law problem, which none of us were capable of doing Scottish law.
Certainly by around 2013, that was a firm called BTO Solicitors.
Those are the ones, yes.
In Scotland. Can you recall the names of any other firms that were involved, either for Scotland
I
or...
can't recall. BTO was the one we dealt with most.
What was your understanding of the prosecution process for cases in these jurisdictions?
I didn't have an understanding at all, I'm afraid.
Looking then at paragraph 9 of your statement, you say the bulk of the poll RMG work was done by Martin Smith, based in Derby, and Andrew Bulk, based in Leicester. They would prepare the cases and brief them out to counsel. The RMG work involved some of the same type of cases as the later poll work, but also involved postmen stealing from the mail. And then at paragraph 10, when he was in Nottingham, Andy Cash would ask my opinion about the poll RMG cases, both informally, and on occasion he would ask me to settle an indictment or an advice on evidence. This would involve the file being brought to Nottingham so that I could work on it. It would then be returned to the lawyer working on it, and I would be unlikely to see it again, as it would usually be briefed out to counsel. So that's what you were referring to earlier in terms of cases going to counsel.
Essentially, yes.
In Crown Court work. You address a case you prosecuted involving a manager of a Crown Post Office at paragraph 12 of your statement.
Yep.
And you say it was a case that post-dated the cessation of prosecution of Horizon cases, and that it was a case that didn't rely upon prosecution Horizon evidence.
Yes.
With this exception, is it your evidence that you did not prosecute a trial?
I never prosecuted a trial for Post Office. I never had conduct of a prosecution brief as counsel or as litigator. I think I did a sentence in Nottingham because it was in Nottingham and that's where I was based. But apart from that, I don't think I did any other court work.
So this case at paragraph 12, when you say you prosecuted it, are you saying it's not one that went to trial?
It pleaded.
Okay, I understand. That can come down now, thank you. You say at paragraph 18 of your statement that your direct contact with Post Office personnel was fairly limited, but that you had dealings with Jarnell Singh, who you understood to be head of crime at Post Office Limited. who did you obtain instructions from at the post office?
Well, I wasn't actually, as I said, instructed in any cases. So I became involved either because Andy Cash would ask me to do something on a case or ask me my opinion about one of the cases. And I was also involved during the SIF process after the second sight review came out. But again, I would have been asked by either Andy Cash or Simon Clark to do the work that I was doing.
So in the instances where you provided written advice,
Yes.
were you not taking direct instructions from the post office?
No, I would be instructed from someone within Cartwright King.
I see. What was your working relationship with Mr. Singh like?
Pretty limited. I met him, I think, on 2 or 3 occasions. Once when Simon Clark and I went down to their Old Street offices in London, and a couple of times when he came up to Nottingham or Derby. And I spoke to him on the phone and emailed. Occasionally he would email with questions and the like, and I would respond. But the main point of contact between Cartwright King and Post Office was Martin Smith.
You say at paragraph 38 of your statement that you were aware from the beginning that the Horizon system was being challenged by the Sub-Postmasters for Justice group. By from the beginning, do you mean from the point that you became involved in any post office prosecutions relying on Horizon evidence?
Yes, I only really became involved in about 2012.
What about the system did you understand was being challenged?
I understood that there were allegations that it was throwing out false figures.
Did you consider at the time you provided advice on post office prosecution cases that you were under a duty to act as a Minister of Justice in preference to the interests of the client who had instructed you in relation to the prosecution?
Yes, certainly.
That this entailed observing the highest standard of integrity and having regard for the public interest?
Yes.
And that you owed a duty to the court to ensure that the proceeding was fair?
Yes.
Prior to being alerted to the content of the interim second sight report, did you ever question whether the evidence generated by the Horizon system could be relied upon for the purposes of prosecutions?
Yes, I mean, we were assured, and it was our instructions, that the system was robust.
And who did you ask, if you questioned it, whether the evidence could be relied upon?
The various caseworkers, the investigators that we're in touch with, later on the various post office lawyers that we came across. But there were all, I mean, one kept an eye on it because this was something that we were going to have to counter. So as far as allegations that the system wasn't robust, we were keeping our eyes out to see if there was any truth in it, if there were any patterns.
Did you receive assurances from Jarnail Singh?
I would have done, yes.
You refer in a number of places in your statement to assurances that you received from all sides that the system was robust and that there was nothing that could undermine the integrity of the system. Were these assurances ones given before the interim second sight report?
Yes.
In this period, that is prior to the interim second sight report, did you ever have difficulty getting information from the post office in relation to prosecutions?
Well, I was doing remarkably little of the work before the second sight report. So the answer is no. If I wanted information, I could get it. But as I say, I didn't hold the brief and I wasn't litigating the cases. It was a question people would ask me to advise on a certain part of a case. It may be that they wanted an interim advice or they may want an advice on a particular thing. It might have been that the advice that they asked for was verbal. I would be asked a question by Andy Cash and I would answer it there and then. But as I said, I wasn't actually working on these cases a very great deal. I had a full caseload of the defence work that I was actually employed by Cartwright King to do.
Could we have on screen, please, paragraph 21 of Mr. Bowyer's statement? That's page 5, towards the bottom, please. And at paragraph 21, you say this: it is probably fair to say that the Cartwright King Post Office Department would have benefited from proper oversight from the earliest stages, from people with actual experience of prosecuting cases, rather than different individuals in different offices doing their own thing. What do you mean by different individuals in different offices doing their own thing?
Well, as I said, the bulk of the work was done by Martin Smith in Derby and Andrew Bolse in Leicester. When I was first aware of the post office work, I was aware that they were doing it and I was aware that they were briefing external counsel. I didn't realise that both had such limited prosecution experience at the time. And as far as that was concerned, that plainly wasn't a safe state of things. But I discovered about that much more when we were reviewing the cases and when we'd effectively stopped prosecuting cases.
Can you help with what you have in mind when you refer to proper oversight from people with actual experience of prosecuting cases?
Well, there are various things. Disclosure, of course, is a main one. Charging advice is a second one. As far as the two individuals who were preparing the cases, as I said, I don't think they had any experience of preparing prosecution cases until they were given this role at Cartwright King.
And who should have provided this oversight, do you think?
Well, it should have been someone, their head of department. Having them in different offices can't have helped. There should have been a post office department where they were in the same room, where they were actually able to pool what knowledge they had together. But that wasn't the case.
It may follow from your answer given just now, but was this lack of proper oversight something which you recognised at the time that you were doing post office work? I became more aware of it after the second sight came in and we were doing the SIFT reviews as to what was actually going on. But as I said, I was based in Nottingham. They were in different counties. Did you raise it at the time with anyone else within Cartwright King as a suggestion?
Not at the time, no. Because as I said, by the time it really became apparent, we weren't prosecuting anymore.
Could we have on screen, please, reference POL 00293276? This is a letter from Cartwright King to Roderick Williams from the Post Office. It's dated the 13th of January 2020, so postdates your departure by around 4 years.
Yeah.
I'd like to ask you, however, about an observation made in this letter about the relationship between Cartwright King and the Post Office. The context for this letter is a review by Cartwright King of the work it had done for the Post Office since April 2012, which concluded that there were a number of improvements and changes in practice which could be made. And going, please, to point 3 on the second page of this document. The author says this: further to the 2 points noted above, we are becoming increasingly concerned at the somewhat disjointed way in which we presently approach poll work. This arises because there is no single dedicated point of contact within Cartwright King for Post Office Limited, as witnessed by the common use of CC'd emails to all 3 Cartwright King lawyers undertaking Post Office Limited work. The problem here is that a lack of continuity on individual pieces of work, together with a deficit in oversight over the landscape in which Cartwright King meets Post Office Limited requirements and advises thereon. In plain English, this means that there is an increasing risk that advice on one topic might fail to take into account the impact of that topic on another area of Post Office Limited work, with the consequent risk that Post Office Limited and Cartwright King are exposed. Of particular concern here is Post Office Limited's disclosure duties arising out of the recent judgment and the need to advise Post Office Limited on current and future Crown Prosecution Service prosecutions. Do you agree with the assessment here of the potential consequences of a lack of oversight, and in particular the risk that advice on one topic might fail to take into account the impact of that topic on another area of Post Office work?
Yes.
And would you agree that that risk was relevant to Post Office disclosure duties in 2012 and onwards, not just at this point in 2020?
Yes.
Is this the type of risk you had in mind when you flag up in the statement to the inquiry the lack of proper oversight?
Yes.
Is it a risk that you recognised at the time?
As I said, my appreciation of how Cartwright King were doing it increased when I got into the SIFT work, because that was when I was actually concentrating on reviewing the cases. But yes, it was plainly unsatisfactory.
That document can come down now, thank you. I'd like to move, please, to the advice you gave in the case of Kim Wiley. You deal with your advice dated the 11th of July 2012 at paragraph 39 of your statement, if you wish to follow. At the time of providing your statement, you had not seen your earlier advice, which is referred to in that July 2012 advice. The inquiry has relatively recently located that initial advice, and I understand that that has been provided to you.
I've seen it.
That is, in fact, dated October 2011 rather than 2010.
Yep.
I think that 2010 date comes from the date given in the July 2012 advice. Could we have on screen, please, POL 004 24121? This is the covering email from you to Robert Daly, dated the 28th of October 2011. Was Robert Daly the investigator in the case?
I'm very probably, but I can't recall.
It is copied to Rob Wilson, head of the Royal Mail Group criminal law team at the time, is that right?
I think so. I think this is probably still under the RMG umbrella.
It is also copied to Andy Cash and Rachel Panter. Can you help with what Rachel Panter's role was at the time?
Well, at the time, I wasn't aware of her role. She was based in Leicester with Andrew Bowles. She was, as I understand it, I think she'd passed her bar exams, but I think she was a comparative baby compared to the role that she appears to have been conducting.
Going then to the initial advice itself, could we have that on screen? The reference is POL 00424122. Can you help, having had the opportunity to read this document, with the purpose of this initial advice? And in particular, was it an advice on whether the prosecution test was met in the case?
Yes, having read it, I can see that there is no discussion of the evidential test or the public interest test, which, looking back on it, there should have been. It's not to say that I wasn't aware of those two particular issues, but I should have discussed them in the advice. It would have been an advice that would have been at the very early stages as to what the evidence we required and the charges that we should prefer.
You set out the prosecution case in the first paragraph, in that at the end of June 2010, Ms. Wiley received a letter informing her that Win Leighton Post Office would be migrating to Horizon Online. On the 9th of July 2010, she reported a 33,142.96 shortage in trading period 4. She could not explain how the shortage had occurred. The HOL advisor, Brian Cordery, reported concerns that he had been presented with money twice whilst conducting a cash check prior to migration. On the 10th of September 2010, an audit was carried out at Win Leighton sub-post office branch by Mr. Jed Dresser and Brian Marshall, post office field support advisors, which revealed a deficit in the accounts of £5,434.93. There is then a summary of what Ms. Wiley said in interview, which included the fact that she could not explain the shortages as she hadn't done anything incorrectly. She says she was aware that the cash would be checked after she received the letter about migration to Horizon Online. She reported the cash shortage after receipt of this letter. And just going over the page, please. She denied theft and false accounting and cast doubt on the integrity of the Horizon system, blaming it for the error. You then say this of the defence case: the most obvious route for the defence in this case is to suggest that the Horizon system is flawed, or possibly that another member of staff stole the money. Just pausing there, this initial advice predates the instruction of Second Sight.
Yes.
You do not seem surprised in this advice that Ms. Wiley was blaming the Horizon system for the loss. Does that mean that this was not the first case in which you were involved, where a sub-postmaster was attributing a shortfall to the problems with the Horizon system?
Well, it was certainly within my knowledge that people were blaming the Horizon system at that stage, yes.
Can you recall how many cases of this nature you had been involved with previously?
As I said, very few at the time.
You deal with the statements which would be needed in the next paragraph. And at the last bullet point in this section, you say, we will need to prove the integrity of the Horizon system as there appears to be apocryphal evidence on the internet that it is causing big losses to postmasters. Can you recall what the evidence on the internet that the Horizon system was causing big losses to postmasters was?
I'm afraid I can't, but the sub-postmasters were making a lot of noise at this particular stage, and obviously we'd heard about it.
Can you recall the basis for your conclusion that it was apocryphal?
Well, because we had no evidence that the Horizon system at that stage was producing these errors, apart from the fact that people said it was.
At the time, did you consider the alternative explanation that those saying that the Horizon system was causing big losses might be right?
Yes, we certainly considered that, and we asked about it. But our instructions were that the system was robust.
You go on under discussion to conclude that the case could properly be charged as 2 counts of theft, and noting that the courts generally do not like theft and false accounting charges to be charged in tandem for the same course of conduct. And you cite there the Eden case. This was a case in which a sub-postmaster had denied theft and false accounting in interview and had raised the integrity of the Horizon system, blaming it for the error in interview, correct?
I can't recall. I haven't read Eden for 12 years.
Well, just going over the paragraphs that we have,
yeah.
This was something that had been raised in interview by the sub.
Oh, yeah, absolutely, yes, of course.
There is no suggestion on the face of this initial advice, and I appreciate you may have had limited information at an early stage, but there's no suggestion here that there had been any investigation of whether the Horizon system was working properly in Ms. Wiley's branch. Would you agree with that?
Yes, and we're talking very early stages. This is an initial advice. I think the advice is dated, what, October, is it? And the audit was September.
In October, yes, to
so
October 2000.
we're at extremely early stage of the case.
Would you have expected the investigator in the case to look into whether the Horizon system was working properly in Ms. Wiley's branch?
I would have expected, as I said earlier in the advice, that we would need to show that the system was working properly.
It isn't something that you advised should be done in this advice. Can you recall whether there was any discussion about whether this should be?
I can't recall.
It was a reasonable line of inquiry, wasn't it, that should have been pursued, the issue having been raised in interview, as a line of inquiry which might point away from the guilt of the suspect. Would you accept that?
Yes.
Did you recognise that at the time?
Yes, I'm sure I did.
What did you do to ensure that that investigation happened?
Well, nothing, because I wrote this advice. It then went off to whichever of the CK solicitors who was prosecuting the case did, and I don't think I saw much more of it until Andy Cash asked me to do the second Wiley advice. As I said, this wasn't my case. I was asked to do the charging advice, but I wasn't in charge. I wasn't the file owner.
You've already recognised that there is no reference to the evidential or public interest tests for prosecution in this initial advice. What prosecution test were you applying when you concluded the case could be properly charged as theft?
Well, I would have had those two tests in mind. As I concede, there should have been discussion of those two factors in this advice. This advice, to that extent, is subpar.
Your advice in relation to statements which would need to be sought included you flagging up that we will need to prove the integrity of the Horizon system. Who did you mean by we?
The prosecution.
Did this include Cartwright King?
Yes.
Was it your view that if evidence of the integrity of the Horizon system overall could be obtained, then this would obviate the need for any specific line of inquiry as to the operation of Horizon in Miss Wiley's branch?
No.
Did you consider at the time of providing this initial advice what the Post Office's disclosure obligations were in the case in respect of other cases in which sub-postmasters were raising Horizon integrity issues?
Not at this particular stage, no, because, as I said, this is an extremely early advice. Statements hadn't been got in, and the initial bundle, I don't think, had been prepared, so no. But as I said, I wasn't running the case, and I wasn't responsible for the disclosure schedules.
As a general principle, at the time, would you have understood that sub-postmasters raising Horizon integrity issues in other cases might be disclosable in this one?
They might be disclosable, yes.
And would it depend on the particular circumstances of the case as to whether they would be?
Well, it would depend on the defence raised in the defence statement. I know, obviously, in those stages, that stage, we were looking at obviously primary disclosure, which was matters which would undermine our case. And as I understood it at the time, there hadn't been a successful challenge of the Horizon system. We were not told about any bugs at the time.
Moving, please, to your advice in the Wiley case dated the 11th of July 2012. Could we have that on screen, please? The reference is POL 001-80894. And going first, please, to the bottom of the third page. We can see there the date of the advice, the 11th of July 2012, and your name at the bottom. Going back to the first page, please. You refer back to your initial advice in the first paragraph, and then you deal with the more recent events at paragraph 2, and you say this: the position of Post Office Limited has, up until now, always been robust. When the system has been challenged in the criminal courts, the system has always been successfully defended. I understand that the Post Office has announced that it has appointed independent forensic accountants, Second Sight Limited, to conduct an independent review of 10 cases based on the Horizon system. Whether this announcement was well considered or not is not an area that I intend to address, but the bell cannot be unrung, and there will be consequences that will have to be dealt with. Before we deal with the substance of this paragraph, I'd like to explore, please, what prompted this particular advice. Could we have on screen, please, POL 001-41393? This is a letter dated the 6th of July 2012. It is from Miss Wiley's defence solicitors to Cartwright King. And it reads: our client has brought to our attention that the Post Office management have decided to allow forensic accountants to examine Horizon. This decision appears to have been made after our client appeared in the Magistrates' Court for the first hearing. In view of the decision that has now been made, as of course our client is maintaining she has not stolen any money and that the fault is due to the Horizon system, what is your position with regards to how this matter is now to proceed? Clearly, we would submit that if the Post Office are now looking at the possibility that there may be an error in the Horizon system, then this case should not proceed further at this time. Perhaps you could advise us as to what stance is to be taken to enable us to consider matters further with regards to possible abuse of process, etc., arguments that may be advanced on behalf of our client. This letter predates your advice by 5 days. Were you advising in response to this letter?
I may have been. I didn't see the letter, but Andy Cash asked me to write the advice, and he may have been triggered by that letter.
Could we have the advice back on screen, please? It's POL 001 80894. Could we turn, please, to the third page of this document, which is subparagraph 6.3. And here you say this: we should ascertain why we have decided to instruct Second Sight Limited. I presume that it was not because of any doubt that we had in our system. If so, we should be robust in stating that is so. I presume our thinking was that as we have nothing to hide, we have no objection to our practices being scrutinised, in which case we should say so. Does it follow from this that at the time of providing this advice, you did not know the basis on which Second Sight had been instructed to undertake its investigation?
I didn't.
Did you ask for any information about the basis on which Second Sight was instructed from the Post Office before providing the advice?
I didn't.
Were you provided with any by anyone else?
No.
In circumstances where you were providing this advice, do you think you should have sought further information as to the basis of Second Sight's instruction?
Oh, in the light of everything I now know, then yes, certainly.
We will come on to the detail of your advice in a moment, but in general terms, you were advising, were you not, on the approach the Post Office ought to take to ongoing prosecutions which relied upon Horizon data. Is that fair?
Yes.
In light of that, do you think that you should have recognised at the time the need to seek more information before providing this advice?
Well, the difficulty is this advice is, I think, almost 12 months before the Second Sight interim review. And the forensic accountants of Second Sight, when they made their interim review, they came out with the fact that they could find no systemic fault in the Horizon system, and they came out with 2 bugs, and that was after a year of speaking to sub-postmasters, access to Fujitsu and access to Post Office. I don't see that I would have done very much better than they would have done.
Going back, please, to the first page of the advice at paragraph 2. Who was it who told you that when the system had been challenged in the criminal courts, the system had always been successfully defended?
I don't know. I think it might have been Andy Cash.
I'm sorry, can you say
It might have been Andy Cash, but I don't know.
This is a point which you list at paragraph 36X of your statement to the inquiry, in support of your understanding at the time that the Horizon system was robust. Did anyone tell you about the acquittal of Maureen McKelvey by a jury in 2004, Mrs. McKelvey having raised Horizon issues in her case?
If they did, I can't remember it.
Did anyone tell you about the acquittal of Suzanne Palmer in 2007, having also raised Horizon issues?
Again, if they did, I can't remember it.
Well, your understanding in both your statement and set out here seems quite clear that the message to you was the system had always been successfully defended.
Yes.
It was not a criminal case, but did anyone tell you about the claim brought by the Post Office against Julie Wolstenholme, which was settled in 2004 after a joint IT expert provided an opinion to the effect that the technology installed at the branch was clearly defective?
No, if they did, I can't remember it.
Also, at paragraph 36 of your statement, you say you were told that there were never any alleged surplus figures generated by the system.
Yes.
Again, can you recall who told you that?
It would have been the investigators or what I picked up from the people who were doing the post office cases.
Can you think of a single person who told you that?
I can't recall, no, but I can recall that was what I was told.
Similarly, at paragraph 36, you say that very few of these problems were being reported in Crown Post Offices. How did you know that very few such problems were being reported?
Because again, I was told that, I think, by investigators.
Looking at the next line in your advice at paragraph 2, where did you get the information that Post Office had announced that Second Sight had been appointed to conduct the review?
Andy Cash.
And the last sentence in this paragraph, whether this announcement was well considered or not is not an area that I intend to address, but the bell cannot be unrung and there will be consequences that will have to be dealt with. What was your view on whether the announcement was well considered? It appears from this that you thought it was not. Is that fair?
I don't think that the announcement itself was a very good idea. I'm not saying that I didn't think the investigation wasn't a good idea, because obviously if there are people saying that the system is false, those particular doubts have to be chased. But the actual announcement of the Second Sight review led to various difficulties, people wanting to adjourn their cases until they had reported, etc. I think, in fact, in the Wiley case, there was such an application for the case to be adjourned until after the Second Sight report, which would have, as things turned out, been over 12 months hence.
Why would that have been a negative thing, people seeking to adjourn pending the outcome of an investigation into the system they were blaming for their losses?
Well, as far as that was concerned, it would have created a logjam. The position of Post Office was very strong. This system was robust.
Was your reaction to the fact of Second Sight having been instructed the same as your reaction to the announcement of it? As in, did you think that was negative?
No, if it were me, I wouldn't have done it. If I were the people that in charge of Post Office, I would have made absolutely certain through Fujitsu that the system was robust. I would have done an internal inquiry and made sure that Fujitsu could guarantee that there were no bugs that could cause what the sub-postmasters for justice were complaining about.
Going on, please, to the next paragraph in your advice, that is paragraph 3. You say here, the first consequence is that we have now given ammunition to those attempting to discredit the Horizon system. The argument will be that there is no smoke without fire, and we would not have needed to audit a bomb-proof system. We can expect this to go viral in that any competent defence solicitor advising in a case such as this will raise the integrity of the Horizon system and put us to proof as to its integrity. As all of our cases depend on the system to compute the alleged losses, this is likely to affect a considerable percentage of our cases. You say in your statement to the inquiry that you have read the judgment of the Court of Appeal in Hamilton and others. Is that right?
I have.
At paragraph 137 of that judgment, and I don't intend to take you to it, I hope you'll take it.
I'll take your word.
There is a criticism that by representing Horizon as reliable and refusing to countenance any suggestion to the contrary, the post office was effectively seeking to reverse the burden of proof, treating what was not more than a shortfall shown by an unreliable system as an incontrovertible loss, proceeding as if it were for the accused to prove that no such loss had occurred. Is your concern here evidence of that approach, the reversing of the burden of proof?
I don't think so.
Does it suggest that you didn't think it would do for the post office to have to evidence the reliability of the data provided to the court in support of its prosecutions?
No, I suggested at this time that we needed an expert in order to demonstrate the reliability of the system.
This last line of paragraph 3, where you highlight that all of our cases depend on the system to compute the alleged losses, was this not a reason for you as a barrister advising on post office prosecutions to be concerned about the potential implications for those who had and were being prosecuted by the post office?
Well, of course it's a concern that the system is challenged, but there were at that time no successful challenges to it. Now, at that time, I hadn't seen and I hadn't reviewed other cases. But later on, obviously, I did get to review cases where there were experts who gave or who provided statements for the defence. And we did not actually have any positive evidence of the system not being robust until the second site presented their interim review 12 months later. And that said that they found nothing systemic with the system. So even then, when we stopped the prosecutions, it wasn't because we thought that the Horizon system was not robust, it's because we thought we had problems with our expert.
Well, at this point in time, all you knew was that Second Sight had been instructed.
Precisely.
Without any information about the basis for that instruction.
Precisely.
And you didn't know what the outcome of the investigation was going to be, did you?
No, of course not.
So did you think, well, if the outcome of this investigation is that there's a problem with the system, a considerable percentage of prosecutions might have proceeded and might continue to proceed on the basis of unreliable evidence?
Well, that didn't concern me at the time, because we were going to get, my advice was we were going to get an expert who was going to attest as to the reliability of the system.
You go on at paragraph 4 to say this: the extra evidence which we will be obliged to gather will be as nothing in comparison to the potential disclosure problems that we may face. Until the Second Sight investigation is concluded, we will be in a limbo. One reading of this is that you considered the Second Sight investigation to be problematic because it might give rise to potential issues in relation to disclosable material. Is that the case?
Well, yeah, to an extent, yes, because obviously as far as Second Sight was concerned, it might raise stuff that was disclosable. But I don't think that I thought that it was going to produce material that was going to be of any relevance to the defence in future, because we were told in terms that the system was robust, and what we needed to do was get an expert to demonstrate that it was. Now, obviously, if Second Sight came back and they discovered faults, that was going to create problems in the future. But that's not what happened.
from the perspective of a prosecutor, is this approach not the wrong way round? In other words, if there was a possibility that an investigation might produce material capable of assisting the defence or undermining the prosecution, then that was a reason to investigate, not a problem.
I can see what you're saying. But as far as I was concerned, if we got an expert who was actually able to attest to the robustness of the system, and the expectation was that Second Sight wasn't going to find anything.
You go on in paragraph 4 to say this: it is essential that the inquiry is completed as soon as possible and we can live by its findings. We will have to find out when this inquiry will report in order that we can choose our strategy. If it is a matter of weeks, then cases can be put over until after it reports. If we're talking months, then the courts will not wear such delays. Might it not have been the case that a judge presented with a well-made application, supported by evidence, would have seen it as important to adjourn or stay proceedings pending the outcome of the investigation?
Well, that's certainly one point of view. It was plainly not my view at the time.
Mr. Bowyer, can I ask you, you're impliedly, if not expressly, critical of the Post Office decision to announce the Second Sight review. But in case X, shall we say, which comes to light, shall we say, 2 weeks after Second Sight has been instructed, and one of the first things that the prosecuting team sees is that the postmaster in interview under caution has blamed Horizon. Would the fact of the investigation then have become disclosable?
I'm sorry, sir, I don't think I understand the question.
Sorry, let me try again. We've got a case which comes to light shortly after Second Sight has been instructed to investigate, and I'm putting this loosely, the reliability of Horizon within the terms of reference of the inquiry, all right?
Yes, certainly.
We then have a case in which there is an apparent shortfall as demonstrated by data from Horizon. And when the sub-postmaster is confronted with that in interview under caution, says, well, I can't explain it. It can only be due, however, to some fault in Horizon. Now, either as part of primary disclosure, but probably more specifically as part of secondary disclosure, would not the fact of the Second Sight review become disclosable?
I'm not entirely sure it would.
All right. I want your view about this, if I may.
Because the whole point of the Second Sight report being commissioned doesn't actually support a defence that Horizon doesn't work, because if the Second Sight report comes back and it says the system is robust, that doesn't support the defence. The fact that someone's investigating it is a worry, in that it does back up, as I say in the advice. There's a no smoke without fire argument, but there is no support for a defence by the fact that someone is investigating.
Remind me, is the test for disclosure that it does undermine the prosecution or support the defence, or that it may?
I think it's may.
Right. So on any view, surely if it's may, then it would be a disclosable document. Oh,
Well,
sorry, not a
disclosable fact, certainly. Yeah.
Yes.
Yes. But the fact the Post Office had made the announcement meant it was in the public domain anyway.
Yeah, but that's what was intriguing me, that you appeared to be critical of an announcement which was, in effect, inevitable, since once there was a case, it would have to be disclosed.
You may be right.
Thank you.
You were in this advice advising on what the Post Office should do in relation to prosecutions going forward, relevant prosecutions. Would you accept that the question which mattered at this point was whether it was possible or fair to continue to prosecute whilst the second site investigation was ongoing?
Well, at the time, I thought it was.
I'm sorry, can you clarify your answer on that? You thought it was what?
I thought it was fair to prosecute if we got an expert demonstrating that the system was robust.
There's no express consideration in this advice, is there, of whether or not it was possible or fair to continue with prosecutions?
No, there wasn't.
Was there any assessment of that question in your mind at all, or was it a foregone conclusion that prosecutions could and should continue?
My view at the time was that they could continue.
At paragraph 5 of your advice, you say this: I assume that we still contend that the system is foolproof, in which case we should defend it aggressively. I understand that the manufacturers have not been helpful up until now. Had someone told you before you drafted this advice that the system was foolproof?
That was the impression that I'd got, yes.
Those are quite strong words, foolproof. Had someone else used those words in describing this to you?
I can't recall where I got it from.
Foolproof is very absolute, and you're making an assumption here that that was the Post Office's position. Given that the Post Office decision to instruct Second Sight to carry out an investigation into the system, was it a safe assumption to make about such an unequivocal position like this?
Well, with hindsight, no, it wasn't. But at the time, I thought it was.
You comment in this paragraph in relation to your understanding about the manufacturers not having been helpful up to now and would not provide expert evidence without large fees being sought. Where did that understanding come from?
I think that came from Andy Cash.
You go on, this will not do. If the integrity of the system is compromised, then the consequences will be catastrophic for all of us, including them. The financial consequences of convictions and confiscation orders being overturned and confidence in the Post Office bookkeeping being restored for future prosecutions will be astronomical. Did you understand at the time that if the system was compromised, then as a prosecutor, the overriding concern should be the impact that this might have on the fairness of past and present prosecutions?
Yes.
Is it fair to say that this advice does not read as though that was your overriding concern?
Well, as an exercise in reading the future, it actually looks fairly good. If the system was compromised, the consequences would be catastrophic, and that's what's happened.
Well, the last sentence here, you say they should be made to understand that this is a firefighting situation and it's not just our house that would be burned down if the system were compromised.
Yeah.
Was it your view that Post Office prosecutions were facing an existential threat?
If the system turned out to be compromised, then yes, it would have been disastrous for them. In fact, it has proved to be disastrous. That's why we're here today.
Did our house include Cartwright King?
No, it was Post Office. As far as Cartwright King was concerned, we were acting on instructions.
You set out a number of steps which should be taken at paragraph 6 of your advice, and we'll come to those in a moment. What we do not see here is an identification of the need for a reasoned and rational basis for continuing to prosecute cases using horizon evidence when an investigation into the system was ongoing. Is that fair?
That is fair.
Would you accept, looking at it now, that that was what was called for in these circumstances?
Certainly, with hindsight.
Was that something you should have recognised at the time?
Yes, as far as that was concerned, if I had my life all over again, I think the advice would be slightly different.
Miss Price, we need to take a break, so just choose a moment shortly, all right?
Yes, sir. That is an appropriate moment for the break, sir, if that's convenient. If we can have 15 minutes,
Yeah,
I'll make it just past 10 past now, so 25 past.
Yeah, certainly.
Thank you, sir. Hello, sir. Can you still see and hear us okay?
Yes, I can.
Mr. Bowyer, turning please to what you did advise in terms of approach, and at paragraph 6, Roman numeral 1. So if we can have that document back up on screen, please. It's POL 001808. There we are. 6.1, if we can go to page 3, please. Starting, there we are. You say, in my view, we should attend to the following. We should identify the contested cases, civil and criminal, in which the Horizon system has been challenged. We should identify the areas of challenge and how we neutralise them. Any expert reports should be retained for evaluation. An expert should be identified and instructed to prepare a generic statement which confirms the integrity of the system and why the attacks so far have been unfounded. This expert should be deployed in all cases where the Horizon system is challenged, and he should be prepared to be called to reply to defence experts on a case-by-case basis. To what extent was your advice here to obtain a generic statement influenced by your understanding in relation to how helpful the manufacturers had been in the past when it came to providing expert evidence, if at all?
I don't think it was influenced by that at all. The idea was that an expert should prepare a statement where the guts of it would be what has actually occurred in the past and what challenges have been made, and that they could comment on the particulars of the particular case that he was being served in.
Having had the opportunity to refresh your memory by reference to some of the correspondence which followed this advice, is it right that your advice led to the production of a generic statement in Gareth Jenkins' name?
It did. I wasn't happy with Gareth Jenkins because I didn't think he was independent, but I was...
We'll come on to that shortly. I think you've seen a transcript of the evidence given by Duncan Atkinson, King's Counsel, on the 18th of December last year. Is that right? He was asked a number of questions about your advice on expert evidence in the Wiley case, and more broadly. I don't intend to take you to the transcript, but if at any point you'd like me to, please do say, and we'll look to it. But I'd like to just run through some of the conclusions Duncan Atkinson reached. First of all, would you accept that what was in fact needed was case-specific expert evidence rather than a generic statement, even where the expert was prepared to be called to reply to defence experts on a case-by-case basis?
Well, the expert report should always be relevant to the case in point, but certain parts of it, rather like a drug statement, will remain the same. So if you are having an expert who is actually commenting on why the system is robust, what the attacks were made on it in the past were, and why they didn't actually have consequence, then that could be deployed in each case with reference to what happened in this particular case, because we had all sorts of different cases alleged. There were people who were alleged to be taking it out of the till. There were people who were alleged to be putting in PIN numbers. There were people who were alleged to be cross-firing postal orders. And so each case would be different. And the allegation as to why Horizon was not working would be different in each case. And that, as far as I saw it, was the way it would work. So the guts of the thing would be there, why it's robust, the attacks on the past. But he would refer to the case itself, otherwise it would be fairly useless in court.
Looking at the way that you have worded paragraph 6.1, which we've just been through, would you accept that this advice was seeking to protect the system rather than to assess the reliability of fundamental evidence in the prosecution of sub-postmasters?
No, I don't accept that. The advice was to say that the system was robust and respond to it. There's no protecting involved. If the system has got faults, they should be disclosed. The whole point was to actually put forward the attacks that have been made on it, and this would be an expert who could actually say the system was robust, and it was also a windmill for the defence experts to tilt at if they were able to actually come up, and the previous attacks on it would be helpful to the defence in that respect.
Was the purpose of advising that a generic statement for use in all Horizon cases should be obtained to obviate the need to investigate as a reasonable line of inquiry whether problems with the Horizon system might have created a loss, an illusory loss, in the branch of a specific suspect?
Well, no, because such a statement wouldn't in fact work in that way. If you were prosecuting a case, you would need to know. If I was prosecution counsel in an individual case, I would need to know why the defence suggestions weren't actually right, and so therefore they would need to be investigated by the expert on a case-by-case basis. I wasn't suggesting having a case to serve blanket in each case, because trial counsel wouldn't have wanted that. They'd have said, well, that's all very well in the past, but in this particular case they're alleging that this has happened. What about it?
Was the purpose of advising that this statement be obtained to obviate the need to identify material capable of undermining the prosecution case, or that if it was in the post office's possession, might undermine the prosecution case in any specific case?
No. The point of it was to actually address the system as to why it was safe, and as far as the defence were concerned, give their experts something to actually get into and give them an expert that they could deal with.
Looking please to paragraph 7 at the bottom of this page. You conclude, I can appreciate that the above might be expensive, but it will be as nothing should the integrity of the Horizon system be compromised. Taking a step back and looking at your advice as a whole, do you accept that there was too much focus in this on the potential fallout for the post office, Fujitsu and Cartwright King, if the integrity of the system was found to be compromised, and insufficient consideration of the implications for the people who had been and continued to be prosecuted on the basis of Horizon data?
No. What I was intending to do was actually create a situation whereby these cases could be prosecuted fairly, with proper disclosure to the defence. Our instructions at the time was that this system was robust, and as far as that was concerned, it would have been a pity if we didn't actually defend the system properly, because if a breach in the robustness of Horizon seemed to have been created, as far as that was concerned, that would have been disastrous. And so what we wanted to do was demonstrate that it was robust, and there was no covering this up. You know, as far as disclosure is concerned, we have always advised disclosure.
Could we have on screen, please, POL 001-43377? Starting, please, towards the bottom of this page. A little further down, please. This is the email from Andy Cash sending your advice to John L. Singh on the 11th of July 2012. He says he encloses advice from Harry Bowyer. I know it will be unpalatable, but for what it may be worth, I share his view. In the instant case, our response must be dependent on timescales for completion of the inspection. We are only just beginning to see these issues raised by defence solicitors, and the sooner we grasp the problem, the better. If you want any more, do call. Otherwise, I will await the outcome of your consultations before responding to the defence. And then, going further up, please. We can see the email above that in the chain, the email from John L. Singh to Andy Cash, copied to Susan Crichton and Mr. Flemington, dated the 16th of July 2012. And Mr. Singh says this: Andy, thank you. I agree defence will approach to stay the prosecution until the review by second sight is completed will become increasingly common. Post Office view is that such an approach be resisted. Review to be conducted is limited in scope in few and isolated cases. Second sight would work with a number of MPs, 2 at present, to review cases that have been raised by their constituents. Second sight's appointment is presently being agreed with the MPs and justice for sub-postmasters. There is no legal or forensic grounds to argue defendants will not get fair trial or abuse of process. There is no reason to justify the case being stayed. The fact that the review is being carried out is not an acknowledgement that there is an issue with Horizon. The system working properly and is being used up and down the country. When the system has been challenged in criminal courts, has been successfully defended. There is no mileage in this position, but is in fact superficial. This was a clear view being expressed by Mr. Singh that the Post Office would not agree to stay relevant prosecutions. Would you agree?
Yes.
And going up to the top of the page, we can see you were copied into Mr. Cash's response. And Mr. Cash says, thanks for this. Do we take it that we resist defence requests in the terms of your email? I would like formal confirmation, bearing in mind the view taken by counsel. If further consultation with Harry or otherwise would assist, please let me know. I will need to reply to Kim Wiley's solicitors this week. Did you understand these to be your instructions, that you should resist requests for a stay from the defence?
Well, as I said, I wasn't instructed in any of these cases.
Did you understand those to be Cartwright King's instructions from this email?
It seems fairly clear, yeah.
In respect of Mr. Singh's comments on your advice more generally, you say in your statement at paragraph 50 that you thought Mr. Singh was somewhat over-optimistic as to the limited effect of commissioning the second sight review. Can you explain, please, why you say that?
Well, he thought that the second sight review was going to be limited. I didn't.
Did you consider at the time that Mr. Singh was minimising the significance of second sight's instruction?
I don't think I gave it that amount of thought, but actually, if I had addressed it, yes, I suspect that would have been my view.
At that time, did you have any reason to think that Mr. Singh was not being fully frank with you about whether there was an issue with the Horizon system?
At that stage, no. I had no reason to believe it.
You say in your statement that you were told by Andy Cash that the Post Office did not like your advice and that you were not asked to advise formally on the issue after that. What were you told about the reason why the Post Office did not like your advice?
Andy Cash, it was a throwaway comment from Andy Cash. They'd seen my advice and didn't like it.
I'd like to turn, please, to the generic Gareth Jenkins statement, which was produced following the July 2012 advice. Could we have on screen, please, POL 001 41416? This top email is from you to John L. Singh, copied to Andy Cash and entitled Horizon Integrity Project. So scrolling down a little, We don't see the sender at the top, but we do see Harry at the bottom there. It is responding to the email below from John L. Singh, dated the 6th of August 2012. Can we scroll down to that? Thank you. His email is to you, copied to Mr. Flemington, and he says this: Harry, it was good to chat with you. I confirm that Helen Rose has been given the task to gather the data. Please find her email and spreadsheet. It would be useful at this stage if you could look at what information Helen has provided and advise accordingly in readiness to instruct an expert as part of providing an advance pack disclosure. Below that is an email from Helen Rose explaining where her work, pulling together information relating to cases in which Horizon issues have been raised. And going back up, please, to the top of the first page, to your email. And you say, this appears to be what we want. Hopefully, Helen will confirm that the Horizon system has never been successfully challenged. I have yet to see any signs of experts briefed on behalf of the defence. When she has completed her exercise, she should prepare a summary of those cases where there is a proper attack on the system, rather than a gripe that the system is at fault, although she should record these cases so that we can say that they have been kept under review. They will become more numerous as the bandwagon picks up speed. The expert will need to address the report to the following issues, and you set out 4 points. A description of the Horizon system in layman's terms so that a jury can understand what it is and what it does. Second, a declaration that it has yet to be attacked successfully. Third, a summary of the basic attacks made on the system, concentrating on any expert reports served in past cases. If there are none, then state that no expert has yet been found by any defence team, civil or criminal, to attack the system. At the moment, there seems to be little more than griping by defendants that the system must be at fault without saying how. And fourth, plainly, like all accounting systems, there is room for human error, keying in wrong amounts, etc. But the expert should be able to state that innocent human error is unlikely to produce the types of discrepancies of many thousands of pounds
Right.
Which his spec came across, said Sky News. I can't see it.
No, it's fine. Sorry.
Oh, wait there. Thanks very much. See the lady in the white dress.
Everyone all good? Mids?
You have to park down here and then you can walk down. We can't have any vehicles come through at this moment in time. If you park up here and then you can come through that way.
And there's another hour. I meant to meet your friend who did. I was meant to be like 6 or something. I pushed it to half. It's down to Saturday. Yeah. Charles, as long as I can get to Central, that's about it. I would like to give you this. No, with that? No, well,
There should be, it used to be earlier, but I can't
there was one before.
I was hoping she turned up too. That's as far as my knowledge.
Oh yeah. Actually, this is like I basically no parent road name.
Oh, okay. Yeah, hopefully it will.
Yeah, that's not bad. We should get the experience in this line as well, so I don't get to do. No, I have, but because obviously I'm on southwest, I don't go there. But I do get quite excited.
Yes, hopefully it goes from there, yeah.
I don't know, worried that she's so ashamed.
Yeah, no worries.
Oh, he's a nice. Yeah.
Have you? Seriously, that long? Still thought it was strong. Hello. Whether it's strong. Right. Oh, yeah. Nice to see you.
I can, yeah. So that anyone basically right hand turn dip down here, come down. It's all a crime scene at the moment.
Yes, you will, yeah.
Possibly, but I don't know. I don't know myself. I don't know. I'll bring the music. Stay this side. Sorry, apologies. Yep. Fine, yeah. Right. Okay. Sorry. The only level protest is going out, down the expert coming in that way, they may be able to let you in from that side. Yeah, but I can't, don't quote me on that. Because I don't know how far they do it down there. Yeah, fine. You go to the alleyway just here, yeah, fine. So, right hand side, yeah. So we go through something the pavement.
I was also wondering whether it contributes, because obviously that's quite far away.
Good.
That's where to get right.
Oh, yeah. Yep. Oh, 2 minutes or 10?
I haven't. I've heard people talk. Yeah, some I know that. We were just making a load of trauma training this afternoon as well. You got right. I don't mind. Yeah, I still have to miss mine this afternoon. Yeah. Very happy.
He's on his way there.
Yeah, I'll take both of you. If you want to take them.
Down there,
Yeah. I'm Charlotte. David Wood mentioned you.
I'm Charlotte Wade.
No, I'm sorry. Charlotte Wood makes it confusing for the two of us.
Right. Yeah, and I really heard getting on. Alright. Yeah, that's alright. It's the drama. I didn't see him. I saw ambulance. Yeah. Yeah. Well, I saw I didn't see an ambulance. I saw one guy in London ambulance service. Then often it's been a thing. Yeah, the whole thing was all at the same time. Yeah.
You know where the
time I wanted to get here was a little right. But I think that was just whatever. I know. If he was building, so I left at night. Yeah. And 2 hours I'm not sure. But for the moment, really? I feel very bad for GEs. That's another thing. You feel quite sort of it's quite hard for me to get people at the time. So often, sorry. Speed.
But at the stage of the last 4 minutes, there wasn't much to say other than the basic facts. Close in the street.
Yeah. Yeah. nice to have this sort of we should be able to we do quite a lot of starts and also sort of family. I like quite I always let some of my love you can't technically say it has bankruptcy. So that's section 114. We had it in Woking as well. Sorry. Yeah, they're like, we're not technically bankrupt because you can't technically say it's bankrupt. But yeah, section 1, which basically that means suspended. Do you have the suspension?
Yeah, but they were going to issue that, but they got
okay, so they got,
Yeah, unfortunately, it's hard to have to stay outside. You can come in once.
I think, there's a lot of these counts.
Yeah, if you park it up there, that shouldn't be a problem. Yeah, no, it's kind of, if you're just walking through, it's fine. You have to find another way.
How soon it will be? No, I mean, we are, everyone's set up literally there waiting. So they said around 4 o'clock.
Authorise all projects without huge amount of their business scrutiny. So they're building these skyscrapers. That's basically centre council. It's very costly. They're basically banking on Woking. Really successful. It's fairly successful because it's only like 25 years. The problem is like they're expecting it to be huge and worse. The pandemic and yeah, there's basically creating this whole housing crisis. Yeah. Nottingham's got now because I went to uni in Nottingham for my undergrad. It's sad to see because Nottingham City has a lot of culture and good venues and things that sportsmen can because they've got the section long forward and they're going to have to just take these cars. Yeah, it's really yeah, but the Birmingham Council right like the metro area.
Whereabouts?
That's where I get obviously in London the width of their and then the London reception.
Yeah, no, I obviously remember this, so I don't know the layout.
I did an interview a few years ago about so far folks to turn out and never expected and sort of get things to go much
So I don't actually know the area. I know that some buses have been redirected.
There's a growing interest in metro networks. We can go to the scenery and invest in the same way with another guy I was getting Like, I find that sort of stuff.
Moving quite freely around the area.
The argument that's
cyber
then they'll do the other way around. They'll make things as well. So it's
didn't quite make 45 minutes.
Well, that's what. I think
maybe it wasn't 11. It was probably like
5. And that's the thing. A Westminster government.
Talking about saying it,
particularly really big hall with wind. Yeah.
Sorry, so you just have to ask about the apologies. Sorry guys, it's all, are you going to the clinic? Get your mind out as well.
I was actually, I interviewed him today and I'd done something to my neck today because something had done my neck. So it was just this awkward interview, just like sat really weird. I was just not like top of the bus, like bouncing around, just in my head. And it's a bit cold, like, what's wrong with this guy?
He's really like.
Yeah, and in terms of like, it's very easy for us to. They're very express team, and actually very. Yeah. The problem is I've put this report together and this is going to happen. I don't know how much of it is
why did this happen, and could it have been prevented? The typical East London side in an instant came people who had been trying to get to work, children who were about to go to
certainly the ones
Maybe not my brain, so I think yeah, they're actually everyone's favourite tree has been I really hope it's that lumberjack.
to get that reaction.
Yes,
That was around like, that's also they're quite young, probably that.
Where do you, we need to know your
on my Twitter, to really report and stuff.
And I really like that. I love my stand.
No, cool. So that was after the attack.
Right, the only problem is I think oh, no. I've got to be looking like you've got mates?
We're okay. I'll go check.
Yeah, you've got mates.
No, I've done.
Should have been, yes.
Oh, you're feeling flushed.
I think it's the calls later now. I can give you one big light and one slightly smaller light. Fierce sunshine, small ones on the the big one I've not really got any modifiers for because I only ever really use it through a softbox.
Okay.
So it's kind of like HMI now. So yeah, it's just a bit blunt.
Do you think this is
yeah. Well, I'll just give it to you. You still do it. The 600 as well. Oh, you've got 600. Oh, yeah. Oh, that's fine. Okay, well, 600. Between the two of those, you'll just be able to spot them. No, I don't know. It's quite easy. Right, sorry,
they're all still in a bit of a huddle just up there, but they're, yeah. I think, Ed, Keith's on his way to replace me.
Ben, yes, he's always had talk, it's a press conference or a scrum or whatever. He would literally just pick his camera up in the air. Now, it looked like a drone, it's so cool. I did see
my wedding service. Sky camera.
It's almost like a realisation that because you're working.
You did it for free anyway.
I saw him. I did see him recently actually. He turned up. I was doing a live play. Yes, it was working for our jazz.
So we're allowing people to come in. Yes, that's fine. Right.
Something should be explained.
How many people are you bringing?
I was going to say,
yeah, that's exactly the conversation.
I believe so, yes.
I don't want to pop too up. No, I'm just concentrating. Yeah, right, okay, just ring me when it's happening. If I can, I'll run down. I'm literally, you see, I'm yeah. Crazy road. I'm right outside the shop. Yeah.
That's a great set. Yeah. And it makes it real.
I'll remember in the series.
That Titan sub-story. That I was fascinated. I've always had the Titan. I found them shipwrecks. That kind of thing very interesting. So something like that.
What's Belfast like? I've never been to Belfast.
Yeah, I know, yeah.
Just want to make sure they can
Okay. So everybody decided here, yeah? Okay, all right. Yeah, I think we'll be looking at 3 minutes, something like that. Yeah, thanks. 3 minutes from now? Yeah. 4 months.
Thank you.
Sorry guys, just to clarify that it's going to be AC Louisa Rolfe from the Met Police, Jazz Atwell, who's the leader of Redmond, and then we've also got a spokesperson from LAS, so
We just said that they were themselves and stuff. I heard someone say street signal was essentially
Okay, in that case, can we make sure that there's a clear pathway, because otherwise it's not going to happen. So Marm Rolfe will give her update, and then we'll meet with LAS, and what might be the last 2 months. That's the second, not the other.
Yeah, and like
I've been retired 5 years. I know there's one to get me wants to retire on that second. We'll wait till the sun. Yeah. So, yeah, those are, yeah, that's right. Yeah, nice to check you. Yeah, so, So, I mean, to say that
well, literally every talk show and every conference. The struggle button. And you're like, you want to research but actually, no one throughout the whole day. But ultimately, it's got the same thing.
Sorry? They're coming.
Oh, and also, yeah.
Right. Get in position to launch.
They go.
just get a shot. Yeah.
London Bridge, that's where the office is. Yeah, the Times. Yeah. No, I'm from Surrey. I live in
us here today, and I'd like to update you with some further details following the terrible incident we saw unfold here. We're also thinking of the 2 members of the public who were injured, as well as brave officers who were stabbed during this incident. The 36-year-old man arrested at the scene is currently in hospital, having suffered injuries when his van collided with a building. He has been arrested on suspicion of murder. At this time, given his injuries, we have been unable to interview him. We know there is speculation about his background, including police contact with him. And despite urgent and extensive checks today, we have found no trace of a prior incident involving him so far, but we will of course continue to make those inquiries. As a matter of urgency, we're trying to understand exactly what happened and why. This was and is a fast-moving and complex incident and investigation, and it will take us some time to establish the facts. This will be our priority in the coming days. With the suspect in custody, we are satisfied there is no threat to the wider community. But this is an incident which has clearly shocked everyone. And over the coming days, you will see a significant police presence in this area. And we'll be remaining here, increasing our patrols and ensuring the community are safe and supported. Please speak to our officers. We are really keen
to speak to anyone who witnessed this incident or has relevant information and would ask that they come forward as soon as possible. We are turning our focus to the wider community and in particular how the incident has impacted young people. We've set up a team of local officers specifically to respond to local community concerns. And finally, I would like to take this opportunity to ask people to think very carefully about what they post on social media. There are some graphic images circulating online, and people should consider the impact of those on the families and those most closely affected by this incident. Thank you.
Good afternoon. I want to begin by saying on behalf of the London Ambulance Service that our thoughts are with all those impacted by this morning's incident and their families. This morning we began to receive 999 calls to our control room suggesting there had been a stabbing in the vicinity of Hainault Underground Station. We dispatched multiple resources including ambulance crews, specialist critical care paramedics and London's Air Ambulance. We declared a significant incident and set up a dedicated operations centre. This allowed us to use our other control rooms to continue to respond to the rest of London. London Ambulance Service worked hard to ensure taking all of them to hospital. Sadly, despite the very best efforts of our teams, a 14-year-old boy has died at hospital. I'd like to pay tribute to LAS colleagues who attended this scene at risk to themselves and to the courage of the police officers injured while protecting the public. I'd also like to thank all our emergency service colleagues who worked alongside us as we responded to this incident. Once again, our thoughts are with the families of those who have been hurt, and on behalf of everyone at the London Ambulance Service, we send our deepest condolences to the friends and family of the young boy who has sadly died.
I'd like to start by saying that the thoughts of everyone at London Fire Brigade are with all those affected by this terrible incident today, particularly the family of the young person who has died and those who have been injured. Firefighters were mobilised early this morning to assist police and London Ambulance Service colleagues at an incident near Hainault Underground Station. Crews were immediately deployed to provide rescue response and assist the emergency service partners in dealing with this incident. We will continue to provide our emergency service colleagues and the Hainault community with our service at this time.
I speak on behalf of Redbridge Council, and of course our thoughts, our prayers, our hearts go out to those affected by this tragic event this morning, where 4 people are still in hospital injured, and tragically 1 lad is no longer with us today. I also want to thank the officers of the 3 services standing next to me, the police, the London Ambulance Service, the Fire Brigade, who heroically stopped further tragedy from happening. Their quick response and putting themselves in harm's way to stop further tragedy from occurring. It's through their quick thinking that they have managed to salvage something out of today. And of course, we as a council will continue to support the 3 emergency services. We will continue to support the wider Hainault community in the coming weeks and months. We're a strong-knit community, very close-knit, and we will continue to work with our community cohesion work here, and we will be there for our residents, our neighbours, as this goes into the future. Thank you.
Thank you.
I'll now make a short statement as the Member of Parliament for Ilford North. Our whole community will be devastated by the heartbreaking news that a 14-year-old boy was killed in the horrific sword attack in Hainault this morning that saw 4 others injured, including 2 Metropolitan Police officers. I can't imagine what that poor boy's family are going through, and they have my deepest heartfelt condolences, and I know the thoughts and prayers not just of this community but our whole country. My prayers are also with the other victims of this horrific attack and their loved ones. I particularly want to thank the emergency services for their courageous response, in particular the heroic Metropolitan Police officers who put themselves in harm's way to protect others. They are the best of us, and I know the injuries sustained by the police officers involved will have really affected our whole Metropolitan Police force. So I want to thank all of those officers who are very visible in our community today. I also know there will be widespread fear and alarm in our community, but the police have made an arrest and are not looking for any other suspects. I'm grateful to the police for their visible and reassuring presence in Hainault today and their commitment to an ongoing presence in the coming days. I came here this afternoon straight from a meeting with the Mayor of London in Ilford, the leader of the London Borough of Redbridge, and have been in regular contact with the Metropolitan Police throughout the day and will keep local residents updated as best I can. Our community deserves answers about what happened. It is vital that we give the police space to do their work. Anyone with any information or footage should provide this directly to the police via 101, and I would urge people to refrain from speculating or posting footage on social media while we wait for the facts to emerge. Thank you very much.
That's it. A few more details. So, no details.
Yeah. No, it's break anyway.
I know.
Hey Lewis. Looking to speed up pressure again on it looked like it was sort of hanging out sort of the mark. I don't know, whether it is good or...